let me block the audio? What? Wait a minute.
Oh yeah, it does.
What?
Just video. I can't even mute it.
Um,
Why?
that's okay. It's here. I got it. So let's hit stop. I'll just manual stop. Let me add it in there. Orders. I'm gonna mute the video. So mute that, and block.
tennis courts.
You don't need my ID.
Okay.
No, if you want to move
So, we're on there.
We see your laptop locked up.
Pardon?
We need your
We're
password.
gonna put on a really good show.
Give John up too. Okay, we're gonna get started. You guys, Natalie and Sarah, if you could lead people over to that side.
There's a water
Okay.
somewhere.
Okay.
Like a.
There's a temporary.
Okay.
Sorry, just to let everybody know who's online, we will be starting momentarily, within the next 5 minutes. We'll just get this. Okay. Now, do you need anything?
No, John went to get me another water.
Okay.
If you do that board, there's markers.
There are a bunch on it. I don't know if I'm going to use it or not.
Pardon? It looks good there. So if you use it, use it. If you don't, you don't. Do you need one-sided material?
You can even just write your name or something.
Because I'm not stupid. I'm going to utilize the work I've already done. Question 6. Part 2. Oh, no.
Okay, guys, I have to move you in. We're starting, okay? And the mics are on, and the sound is just going all over the place. Okay, so if anyone comes in, they register, move them in the seats. Okay?
Are you closing the door?
Okay, are we ready? We're ready? Yeah, please.
Do you want to do your intro or?
Okay. Good evening. My name is Lori Marshall, and I welcome everybody here live and everybody here on webcast. And Leanne Moore is our presenter tonight. If you need any help, I'm willing to step in. And it's on practice management. You should have had the materials live and webcast emailed to you, and the link should be working. So we have a live chat feature. In order for the Law Society to count the hours, there must be a live chat via webcast. So ask questions. We have 2 chat monitors, and I guess we can get started. Leanne is a licensed paralegal in Oshawa, and she's licensed by the Law Society, and she runs Cochrane Moore Paralegals, and I'll let you tell a little bit about your firm because you're expanding in areas of practice. And this CPD is meant to cover anything and everything you need to know about practice management, including precedents. Okay, so the package, I went through it, it's quite impressive, and I'd like to say thank you for everybody for signing in. Happy holidays, Merry Christmas, Happy Hanukkah, and without further ado.
Thank you. Okay, so thank you, Lori. My name is Leanne Moore. I'm a managing partner at Cochrane Moore LLP. We're a firm in downtown Oshawa. We've just recently expanded out, so we were up a little bit further north. We're now downtown. Far bigger space, a lot nicer. So today we're going to run through practice management. At our office, we have 3 partners. We each handle different areas of law. So to keep things consistent, we like to have one system in place that just translates across to everybody's different files. So I have brought just a template just to show everyone, and I know everyone has their own filing system, so please don't think that I'm saying this is the only way to do it. This is the way that we do it. It works well for us. We have a file for each different portion of the matter, I'll call it. So I'm going to get into this a little bit later, but this is what our filing system looks like. Each file folder gets a nice little stamp on the front. We fill out the client information. It's easily accessible and quick to find. So what I'd like to do today is just go through a breakdown of a client call right through to closing or transferring out a file. So we're going to be here for a couple of hours. I will try to get everyone out of here by 8:50, Lori? 8:50, I'm getting a nod, yeah, okay. So if I'm getting close to that, if someone would just give me a reminder because I do talk a lot. So from the beginning, with your business, the biggest risk that I find we run is in phantom clients. The phone rings, we have no idea who it is. We answer the phone and people immediately start giving you information. So they'll start spewing their name and address and what happened. You get their whole life story before you have a chance to do a conflict check. So the first thing we do in our office is perform a conflict check. The second the phone rings, stop talking, don't tell me anything. What's your name and what's the name of the other parties involved? From there, we can find out whether or not we can assist you and take any more information. So from that point, we actually just use Excel. We were using ULaw. We found the software wasn't doing what we need to do, and Excel performed perfectly fine. So we have shifted off of ULaw and into just paying a bookkeeper to do the financial side of things, and we handle our conflicts through Excel, which works great. Control F, and you have the information you need. So in your packets, you'll find a prospective client checklist. So it should be page 2 after your cover page. This is something that our firm insists on using, so we keep them at the front desk with reception. And any call that comes in gets the date of contact, the person's name, the parties. Was a conflict check performed, yes or no? What names did you search? What spellings did you search? Because obviously it's difficult to always get the accurate, correct spelling of people's names without asking 400 times. So we go through and we fill out this sheet, it gets put into the client file, and then we know right away, has a non-engagement letter been sent? Do they have a scheduled appointment? Have we verified ID? This information is right there at the front of the file. It's easily accessible. So for a client phoning in, again, I cannot stress enough, conflict checked immediately. Then after a conflict check is done and we've confirmed, we can take this client, we can listen to them, we can take their information. We don't take it over the phone. We schedule an appointment, we like a face-to-face, bring all of your documents, give us an opportunity to review it, discuss it face-to-face. And if you're comfortable with us and we're comfortable with you, then we'll go ahead and sign a retainer agreement and move forward with your matter. So, often, we're not available the same day that someone phones in. So we're going to get a call on a Monday, and that person likely is not going to make it into our office until Wednesday, Thursday, maybe even the following week or 2 weeks down the road, depending on their calendar. So by the time that person comes back for their actual meeting, we may have retained someone else. So we need to do another conflict check. So they come into the office and they're then given a second conflict check to make sure that we haven't crossed over any paths. And we have a file opening checklist that we run through. So this is internal, this isn't something that the client gets access to. This is something that, again, stays at reception, and we just go through and say, okay, yes, we've done our conflict check again, and we've noted the limitation periods that they may have accidentally given us over the phone. And we've confirmed just through a quick conversation that this person does have the capacity to retain and communicate with our office. We don't need to send them out. We don't need to turn them away. So I've attached the file opening checklist for you. Whether you do this the second someone comes into the office or whether you do it after they've left your office, I don't think, in my opinion, it doesn't really matter as long as it's done around the time that you're opening your file. So usually, to be honest, this is done when we open the file up. First thing we have the client do when they come in is fill out a client intake. So I've attached a copy of ours for you. And what we've done with our client intake is we've included their date, their name, their address, their phone number, their email, all the contact information. We've got their employer's information so we know how to reach them. But we've also included the ID verification in here. And the reason we include the ID verification here is because it's something that you have to do if you collect funds. It's not something that you have to do if the person is not going to be giving you money. So I don't have to do this here. I do it here because I don't want to have to remember to do it later, because that's where mistakes get made. Do it right away, do it when you think of it, have a system in place, and then you don't have to worry about it, it's finished. So with the ID verification, does anyone know what the exceptions are to verifying ID? When do you not need to do that yourself? Anyone? Yep.
Is one of them when you're dealing with a banking institution or government?
Banking or government? It's not one of the ones on my list. I have 3 on our list. The Law Society. That would be when you were employed and it's someone that is inside that's already been verified through your employer. When you're accepting a file transfer from another practitioner and they've already done the ID verification. And I'm going to double check to make sure that I have the correct exception. When you're acting as an agent for someone who's already done the ID. So if I attend provincial offences court as an agent for another individual, I'm not going to check the ID of the client because they've already done that. I have to trust that the supervising paralegal has taken care of that. So now that we've done our client intake and verification, we've gathered the information that we need from this individual, we're going to find out if there's anyone else that's going to need to communicate with us. And this is something that we were doing a little bit later. You find out after 2 or 3 months that there's a boyfriend involved and he's really the only person who's going to be contacting. It's not a joint retainer, but he needs to have access to collect information or to pass us information. So now we ask that during the intake and we have a third-party authorization form completed. So I've included a copy of that as well. It's a couple of pages in. So our client intake is pages 2 to the public and 1 to us. The second page is to find out how they found us, were they referred by a friend, and do they have any upcoming limitation periods that they're aware of. And this is something that we'll discuss with them anyways. I'm not going to take their word for it. But I'd like to find out if they know off the top of their head if there's anything available. And then we have just a little paragraph here that explains to them that this is not a retainer, this is not a contract. This is really just to say everything I told you here is true, and I'm not lying to you. That's it. And the last page is for internal office use. So this just says, who is the individual who verified the ID? Did they check the limitation periods by noting it on documents? Was it just something that they were told? And from their cursory consult, are they willing to represent? Or should this person be sent a non-engagement letter? And was that done? And then we have space for notes. We never use it. We actually have communication forms that get used because, as you know, an intake usually has, 30 minutes free equals an hour and a half of your time. So here's your verification of identity if you do not have it on your intake. This is the information the Law Society wants to see. Like I said, I put it on the intake because then I'm giving them 1 form instead of 3, but you can do it with an individual form as well. They want to see a driver's license, passport, some sort of government photo ID to ensure that this is the individual, you know who your client is. And they want to see that person's employer, place of business, and so on, so that they know that if that person is hit by a bus, you know who to return the file to. Now the next page after that is the third-party authorization that I mentioned earlier. So this is the one that we have them complete if there's another party that may need to pass us the information. So if that person is often at work in the evenings and can't get in touch with us, the boyfriend may want to stop by and drop off documents. I want to know that that's okay to accept. I'm not getting information from a stranger. And of course, with an organization, we have a separate form. So organizations are a little bit more fun because you have to find out immediately what type of business is it. And oddly enough, people often don't know. They can't remember if they incorporated, if they're limited, or if they're LTD, or if they're... So it's very important that you find out and you get either a partnership agreement or the Articles of Incorporation, something that will identify that business and the shareholders, directors, or whatever the case may be. We also want photo ID from the authorizing party to make sure that we know who we're allowed to communicate with in that business and organization. So from there, and this is something that is a best practice, and I'm not going to lie, I don't always do it. We should be sending out a letter of engagement. And the reason I don't, actually, you know what? I've included the letter of non-engagement first. We do always do. The letter of non-engagement would be there for a client that has done a consult and you found out during the consultation their limitation period has already passed, the matter's outside of your scope, you need to pass it off to a lawyer. Just CYA, make sure that you're letting the client know in writing, I will not be assisting you. You want to include any pertinent limitation periods. You want to include a very strict line that says, I am not helping you. We will not take any action on your matter. So we've included a template that's really more of a almost bullet point, just to give you a breakdown of the things that you need to see in a non-engagement letter. The format of our letter is the Laurie Marshall style. So we learned this from Laurie Marshall, and we all of our letters off of this format. We always enclose anything. So with a consult, oftentimes the individual will leave you with originating documents. They'll leave you with evidence that they don't have a second copy of. Oftentimes, I will try to just take a copy of it while they're there and return their originals. Sometimes they say, no, you keep it. And then we have to non-engage. So we always make sure that that gets enclosed with the letter and it's returned. And we make sure that everything goes back to that client. If I am enclosing originating documents, I don't send it by letter mail. I send it by registered mail to make sure that there's a signature to accept. So that way I can guarantee that that person did get it. And if I don't get a signature, it comes back to me and we'll find another way to get it back to them. Laurie Marshall.
Just to make it very clear, okay, these aren't necessary. I can't take the credit for these letters. They can be found in Legal Office Procedures by Tina Kamakaris. Okay.
Oh, the formats? Mm-hmm. Okay. We stole your templates and
or in my letter guide.
Yes, we drafted the letters, but we took Laurie's styles. So now that we know the client is going to be engaged, we are going to be moving forward with their matter. They like us, we like them, they're inside the limitation period, everything lines up, and it's going to be a good case for us to take. We know we're confident and capable of handling it. Then we will start up our ongoing file checklist. And this is when we will create, and we stole this term from Scott McEachern, so I will give him full credit. We stole his rainbows. So this is what we use. We have different colors, and I like ours more. But we set it up with slight variation on Mr. McEachern. We have our client folder, which goes to client communication. We have internal memos that will end up in here. We have retainer agreements. All of that ends up on this side of your folder. And all the client communication, being telephone calls or emails, will end up on the other. We then move into opposing. We have one for each party. And as some of you may know, you will sometimes end up in situations where you have 3 or 4 opposing parties. Each of them get their own folder to make sure that it's quick and easy to identify. And if you're in court and they say, I didn't get that, well, actually, yes, you did. We then have a court forms folder. And again, when you run into D1, D2, D3, small claims, or multiple respondents, you want to make sure you have a separate court form for each matter. Evidence, which is only photocopies. We do not keep original documents in these folders. They end up in a separate folder that stays in either the safe or in their filing cabinet locked up. We have our authorities, and then we have everyone's favorite, the accounting folder. So in our accounting folder, we keep all of receipts and disbursements and invoices on this side along with the trust ledger. On this side, all dockets that have been interim billed out. I'm not going to get too into docketing or trust accounting or anything like that today because that's really a full day on its own and nobody likes it, except maybe Laurie. So
Just yeah, it's me. I happen to like it.
So with our ongoing file checklist, we've now set up their file. We've given them a number based on the numbering system that we use internally. I don't base it off of the court filing number because oftentimes, like I said, you'll end up with a D1, D2, D3. I like to have things simple, and we have just a running tab in our office. Our electronic files match our hard copy files, so it's quick and easy to find, and we label everything with the file number, which is the date and then the number of that year. And then we have the client's last name, comma, first name. And that's how every file in our office is labeled. And that means that anything that Jonathan is working on or Colin is working on, I can run in and jump and grab something from their file and I know exactly where it's going. So again, the ongoing file management list is really based on our office procedures. So I don't say that this is the greatest way to do it. I just say that this works very well for our office. So storage is probably the most important thing when it comes to file management. And the reason I say that is because we're turning into an electronic age, and without a reliable online source to store, I'm finding that you run into a number of problems. You see a lot of people now in court with tablets, and they're sitting there checking calendars, and they're pulling up client files in the middle of court from their tablets. They're not using hard copies anymore. We do because we're old school and we like the hard copy, but at the end of the day, our electronic storage matches our hard copy. So if there's a fire in our office or something happens, we can fall back on that Google Drive. We use Google Drive instead of Dropbox. I know there's kind of split theories. People have a system that they prefer, whether it's Dropbox or Drive. When we started up, the Law Society had actually made note that Drive was acceptable and Dropbox wasn't. That's why we went that way. I think they both have their downsides, they both have their positives, so it's really up to you as an individual. One of my biggest downsides was that Dropbox is a lot more expensive, and as a new firm, we didn't want to incur that cost. But I think the reliability of Google Drive, when you have multiple computers operating off of it, is coming into question for us, so we might be looking to make a change in the very near future. Law Society also wants multiple backups. So when you are getting into file storage, whether it's open or closed, you need to make sure that you have a backup to your backup. We have Google Drive and we have our hard copies, but we also keep a hard drive. And that way, if something happens to Google and everything goes kablooey, we have a hard drive system as well that backs everything up, and we can pick up and run again. Yeah.
Ed Woods and our IT guy, if anyone has any questions as to buying a cloud so you don't have ongoing costs, ours was $526, including tax, one time, and all of our documents unlimited or somewhere in cyberspace, and approved by the Law Society. So you have that on.
That's good to know.
Yeah.
I'll be calling Ed. Expect a call, Ed.
Dan for that.
Dan? Okay. Dan Sperry is Catherine Sperry's husband. Catherine is Lori's business partner, for anyone who isn't familiar. The other note on storage that I have here is that you want to make sure that your items are clearly labeled. So this goes to closed files and open. As you know, if a client walks in, and oddly enough, we had an LTV a couple of weeks ago who came in, and it was a real estate issue where the father had passed away and we had to proceed for the heir. We needed the power of attorney, the will, we need all of these sensitive documents that have to be protected. So they must be clearly labeled and set into a safe, so that if there's a fire in our office, that fireproof safe will protect those documents that would cause our client a lot of grief. So anything that you're doing with trust for clients, whether it's a diamond ring that is in dispute or will and last will and testament, it needs to be secured and clearly labeled so that should something happen to you, anyone else in your office can go and grab it. So I don't want to get too into retainer agreements because I know that everyone, again, has their own style. I've included a copy of ours. It's 6 pages, and this is just one of our basics, just so that everyone has an idea of what we work off of. And there are some things that I do want to point out with them. Now, right on our retainer agreement, we identify who the supervising paralegal will be. So right there at the top, I've included my name for the purposes of this. But if my business partner, Colin, is taking on a client, he'll say Colin Cochran, Cochran Moore LLP. That way there's no issue down the road. We know right away who is the primary, and that person can be referred to. In your retainer agreement as well, I always make it very clear. First paragraph, this agreement relates to this matter. So we're dealing with Moore v. T-Bart and but we have clearly identified who this matter is against, because often you'll have a client that comes in, they're being sued by party A, and then 3 weeks later they're coming in because they're being sued by party B or C, and now you're dealing with 3 or 4 active files for the same person. So you want to make sure that they're aware this retainer covers party A, and if another suit or speeding ticket or parking ticket or anything else comes up, it's going to require a new retainer, new funds into trust. We also include a clause that allows us to give provides us authorization to act. So we state in our retainer agreement that we may have an agent attend on your behalf. We may have another party attend on your behalf. So although I'm the primary on this particular retainer, I may have to send Colin out to go and attend the matter if I'm unavailable for whatever reason. So we have our clients agree to that in our retainer agreement. We explain it very clearly. We get them to give us the authorization to attend court on their behalf, to attend settlement, to make agreements, to do whatever we need to do to resolve their matter. We also lay out a timeline and expectation because we want our clients to know that just because you've hired me today doesn't mean your matter will be resolved tomorrow. And I know a lot of people want that to happen, but it's just not the way that it goes. So in a small claims matter, we may tell them it could be up to 24 months or 36 months, and sometimes we'll set a longer expectation for a more complicated matter, and 4 months for a landlord-tenant matter. But it might be 2. But we try to set what we think will be a reasonable time frame for that particular matter. We also lay out our fees. We have that included in the retainer so the client can see at a glance how much do they have to pay us, how much will we charge them per hour, and of course this is not touching on contingencies, which I'll come back to in a second. We then go through all of the responsibilities of our client to make sure that they know that they have a job to do as well. We're not going to do the investigative work for them. We're not going to pull transcripts or do anything else. So if they want any of that done, they can pay us extra to do it, or they can do it themselves. But we make it very clear what their responsibilities are and what we are not willing to do. There are 2 more clauses that I really want to point out. The next one being termination, because I'm going to come back to this later on in materials. And termination clause is extremely important. It spells out why you can get rid of your client. And there aren't many reasons. A client can give you notice on a dime, and you will stop work immediately, unless you're in quasi-criminal or criminal. I know they have some different rules that they have to follow. I don't practice in those areas, so I'm not familiar with those rules. But I have been told that you have a request to be removed, and it takes 30 days in writing and some other things. So I'm not going to touch on that, but with our retainers, with small claims, with anything HRTO, if they tell us to stop working, we stop working. If we want to terminate a client, it's because they've lied to us. That's usually the reason we're terminating. I don't often find myself in a situation where there's another reason. I can't really think of anything offhand.
I think that's the only reason we've ever had.
Yeah.
Breakdown of relationship.
That's what we call it.
If the client loses faith in you.
Will that be a reason they would terminate me?
We're talking about why we fire them.
No, I fire them. I have one that, human rights, and I'm responsible for communicating to the HRTO the client phoned. Now I want to get rid of the client. Oops, relationship broke down, you don't trust me. That's this weekend. Bye.
Okay.
Yeah.
So that'd be a reason. For us, I find it's usually because they've lied. Because they told me that they got fired 2 weeks ago, and it turns out they were fired 3 years ago. It happens, believe it or not. So that's our primary reason for terminating. And what we do when we terminate is we go through and we document every detail of that claim. We document the date that they came in, everything we did, and every day we did it, and every piece of paper that we looked at to make sure that at the end of the day that client isn't going to come back and sue me for having missed the limitation period. So we're very careful with our termination letters. I have included a sample for you, but we include it right in the clause. And the reason I'm pointing this out is because with a contingency agreement, it's a little bit different. When you get into even just the breakdown of your fees, you need to be including examples of how that fee structure will look at the end. And we always give them a full example. If I'm taking 20%, you win, as an example, $20,000 plus your HST, plus your disbursements, plus my fee. This is how much you're getting at the end of it. Big letters, this is an example. And then we have them initial next to it to make sure they understand, yes, okay, this is how much money I'll lose at the end of it. Often we end up reducing our fee, but we have to make sure that they fully understand what they're getting into. And in the termination, the reason I bring this up is because we include a clause that converts that fee to an hourly base. So if a client hires me and I put in 30 hours of work on their human rights file and then they terminate me, I want to get paid because I took 30 hours on contingency with the expectation I would be winning and would get paid at the end. So I need to make sure that I get paid for that time. So we put in a clause that says your rate will convert to hourly. We have them initial, we have explain everything, and that's included as part of our retainer agreement. And the last thing that we include in our retainer agreement is our confidentiality clause. And the reason that we include this, it's not so much to let the client know that we will protect their information, because I think they already know that and they expect that. This is to let them know that we will communicate by email, possibly text message, and by phone. And I have no control over Google. So I will password protect everything on my end, but I can't guarantee that Google won't get hacked. So we include a clause and an initial line next to each person to give us permission to communicate in that manner with our clients. Because what's okay with that, I mean, it's more convenient for me, but I need to make sure that they know that I can't control it if something happens. So we do our best, but we like to make sure they know so far. Okay, when do you want break? Just so I have an idea.
We're only going to take 10 tonight, so we can get out earlier. Oh, 7?
7?
7? Quarter after.
Okay.
Is that our most recent item here, ILA?
ILA is in there. Like I said, I didn't go through every clause of the retainer. Clause in here about jurisdiction. If you want to sue me after this is over, you're going to do it in Ontario. I'm not going to Alberta. We have an independent legal advice clause that allows you the opportunity to take our retainer and go and seek ILA or waive it, but we explain it very carefully. And we also advise our clients right in our retainer agreement, and I don't know if everyone does, but we definitely let them know you have the opportunity to file a complaint with the Law Society if you don't like the services I've given you. Very important. And I will provide my clients the number happily if they have an issue. We haven't had any issues. I hope we never do, but that information is readily available to our clients. Yeah.
Just wondering, going back to the text messages, how do you print them off? Do you get a screen capture?
Yeah.
Okay.
Yeah. So
it's not often they have a date and time on them sometimes, so.
Mine do.
Do they? Okay.
Yeah, if they didn't, I wouldn't accept them.
Okay.
But my phone does allow me to view detail if it's not showing right there on the screen.
Okay.
But the printer that we have, Dan Sparty, thank you, we have an app that allows us to actually print straight from our phone. So we just screen capture and print the picture straight to the printer at the office. So it's actually pretty convenient. It's about the same amount of time as an email for me, so it really doesn't make a difference to our office if it's an email or a text. The only concern I ever have is if it gets bumped down my text line and then I don't see it. But we do always advise clients, email is preferable. Actually, would rather them communicate by email than phone call. So moving then into how our next steps after we've retained, they've given us the money, they've signed the retainer, everyone's happy, we have a great relationship starting. This is the part that we don't always do. And maybe we should always be doing it, but we don't always do it. Lori's probably not happy. We don't always send a letter of engagement. And the reason we don't always send a letter of engagement is because it's fairly time consuming to just say thank you for coming in, it was nice meeting you, and we're going to start working on your file. We usually wait until we have something to update them about, because when you have that many active files, it gets a little bit redundant to send a letter to every single person to say, hey, I know we just met yesterday, but it was so great, thanks so much. It's good practice, and I mean, I'm sure clients appreciate knowing you're thinking about them. Frankly, I just don't have that kind of time, and my partners don't either. So if you hire us, you can expect to not receive a letter of engagement. But I have included one for you just so you have an idea of how they should look. I find they're basically a reiteration of your retainer agreement, which I provide my client a copy of. So for me, I don't really see the necessity. I think they're kind of an alternative to retainer agreements, and I don't like that. So I'm far more comfortable having the client retained properly than to rely on a letter. So now that we have started our matter, I'm going to skip this next letter and come back to it because I actually put them in the wrong order, so I apologize. Now that we have started this matter and we're starting to receive documents from the court, we're going to notify our client that we have a trial coming up. So we've received the notice that their trial is scheduled for a 2-day matter that's going to be January 17 and February 20th. So we've included both dates in here. We've also at the bottom enclosed a copy of the notice of trial, notice of settlement, whatever the case is. We always include a copy of it to the client. It either goes out by email or by regular letter mail. I prefer email because it's quick and you can guarantee that someone's received it when you have a read receipt. But oftentimes, some Collins clients at least are not very tech savvy. A lot of them don't even have email addresses. So we're sending a lot of documents out to them by regular snail mail. So in our notice of trial, we're going to include the time, and I'm going to include the location as well. By email, I actually include a map so that the client is just guaranteed to be there, because there's nothing worse than showing up and getting the call, I don't know where I'm going. So we include a screenshot of the map or a link to Google Maps to give them the location, the notice of trial, and then we always tell them to be there at least a half hour early, because guaranteed on the day of, whether it's a settlement conference, an LTV hearing, a mediation, it doesn't matter what it is, they will have last minute questions that they forgot to ask you 3, 4, 5 weeks before. So morning of, we always have them show up early, we have a meeting place, we explain to them where it is, how to get there, and then we're rolling. We also confirm in the letter there's nothing outstanding, we have all the documents we need, and we've arranged dates or times to speak with witnesses to do our prep. Yeah. Chat question.
Sandy A would just like to know why a email would be sent on your behalf as a quicker engagement option.
Sorry?
She just asked why you wouldn't send an email. She said it was a quicker engagement letter option instead of proceeding later, I'm assuming, but I just not sure.
So,
she didn't hear you.
Okay, sorry, she wants to know why I wouldn't send an email engagement letter instead of drafting a formal letter of engagement?
Yes.
Okay, again, I go back to, because honestly, we get so busy that I don't always have time to send an email to say thank you for coming in. And I know Scott is just like shaking his head because Scott is amazing with his client relationships and in building that and maintaining that. So he is on it, and he always makes sure that his clients get a letter of engagement to say thank you, it was so lovely seeing you, here's a link, read more about me and our company, and this is an article that relates to your matter. I wish that I could find time. I don't know how you do it, honestly, because I know how much you have on your plate. So I have no excuse. I simply don't.
I'll be honest. I'm not perfect.
Yeah, it's very difficult when you start managing the number of clients that you start to manage. I mean, when we started out, every client got that. Every client, I could have sent them a bouquet of flowers and tied the knots and made them myself, but as your business grows and you start to grow in your client base, you just don't have time, even for a quick email. It just doesn't always happen. So I say it's a best practice. I say it's something you should do, but I'm also not going to hold it against someone if they don't have time. And again, I find it's mostly a reiteration of your retainer agreement, so I don't really need to be doing that. So I think we've covered our notices and what we do to send those out. Those are extremely important. Those ones always go out because I need to make sure that my client will be in attendance. Moving into interim reporting letters. So again, I've just included a very brief sample here for you. So we're just telling them the letter is sent with the intention of updating them on their matter. There's nothing super pressing, but we did do, in this case, I think we adjourned a T2 hearing date
filed a new T1 application and we've requested they be heard together. So this is just something we want to do to let the client know we followed your instructions, everything's rolling along exactly the way we said it would, and it's all fantastic. And here's your bill for all of our fantastic work. So we include a statement of account, it's enclosed at the bottom, and now our client knows that we're pulling money from their trust. Often the interim reporting letter is where they'll see a reminder that they're going to have to top up their account depending on how much money they had up front. And we remind them that they can call us anytime if they need to reach us. Now you'll note also on all of our letters, we always include a sent via. So whether it's sent via facsimile, regular letter mail, or even email, we include that line just because, not for my client's sake, but for my own. Because down the road, in 3 or 4 weeks, I'm not going to remember how that letter went out. And there have been enough nights where you wake up at 2 o'clock in the morning going, did it go out? And then you have to refer back to the file first thing in the morning to find out, or from your phone at 2 o'clock in the morning. So we include it just so that it's a note and I can say, okay, yes, it definitely went out, it was sent by this, and I've jogged my memory, or I've seen the scribble on the page that said it was mailed. So now that we've rescheduled this individual's hearing dates, we've received an offer. So we have an offers checklist, and again, it doesn't always get used as a checklist, but it is a mental checklist that we run through. Did we notify the client of the offer? Have we reviewed the offer to make sure that there's nothing fishy, we don't see anything that might prejudice our client or hurt them? And did we get our client's written authorization to accept the offer? We do not accept offers without written authorization. So oftentimes you'll call a client and say, great news, we got an offer and it's so awesome. You should totally take it if you want. They say, I'm so happy, I want to take it right now, sign it, sign it, sign it. Send me an email first. Here's an authorization. We don't sign anything on behalf of our clients without a written authorization from them, and it's extremely important to remember because maybe not so much in small claims or in HRTO because you have a bit more time between your matters, but with provincial offenses and criminal laws, sometimes you're in there and it's a plea deal that's just on a dime. And you need to make sure that you have your client's authorization in advance to make sure that if a plea better than this comes in, you can. So again, I don't practice in those areas of law, but I've heard a number of complaints about not having authorization to accept a plea. It's extremely important to make sure that you're prepared for that. Scott?
On offers, say on a small claims matter, perhaps you could touch on what should be done when you have a joint client, perhaps.
Yeah, joint clients are fun, aren't they? Mm. Yeah, there's a special deal with joint retainers with especially small claims. Because if I am representing 2 individuals as defendants or plaintiffs, and John is representing 1 individual, John can send one of my parties an offer and not the other. Say, hey, withdraw your claim and I'll give you this much. As their representative, I have to act in the interest of both parties, and I'm now prejudiced and in conflict, and I may have to step out of representing. Yeah.
Yeah, sorry about that. What I meant, and my apology for putting me on the spot without being clear. What I meant is, for example, if an offer was to come in to a husband and wife saying, hey, you guys are the plaintiffs, I'm willing to settle for $10,000. So you send an email off to both husband and wife, and the husband gets back to you and says, yeah, sounds good, we accept, take it.
No, I want it from both of them. Yeah, no, one party is not enough to speak to accepting an offer because likely that husband is just excited and taking that offer, and then the wife is going to slap him and she's going to slap me. So no, we always make sure that we have written authorization from all parties to a retainer. I don't like joint retainers. I mean, they happen, you can't avoid it, but I really don't like them because it always puts you for someone to send an offer to one person and not the other, or you're in a position where one party wants to accept an offer and the other won't, and it really just breeds conflict. So yeah.
My apology, I don't mean to hijack your presentation.
Go for it.
One of the things that I do, though, very early on when I'm establishing a relationship with joint retainers, so in the initial retainer meeting, if I have a husband and wife there, I'll simply explain the joint retainer terms, and I lighten the mood by saying, hey, something that's important here is the two of you are going to have to stay singing on the same page. If we get an offer in for $5,000 and one of you says accept it and the other one says no, no way until the sun comes down, or whatever your phrase is, then we as paralegals, we have a problem. We can't do two separate things for two clients, even though they're jointly retained. And of course, the rule is we'd have to, unless they come together, we'd have to back away until each one get their own separate representation. But what I try to do is make sure that joint clients know from the early on that they need to be joint in their decision making, and that I can't take different instructions from the two clients. And that sort of sets the tone so that later when it comes along and it actually does happen, they're already going to have had that discussion. And then, so when you send them back an email saying, sorry, I need two emails, one from Mr. and one from Mrs., they expect that.
You included in the retainer as well?
Yes. Yes. Yeah, you have a special clause for joint retainers where you have them initial that they understand what the ramifications are if they disagree. And it's very important that Scott points that out. That is a very important clause to have in your joint retainers. Do not sign a retainer with two parties without that clause. And make sure they initial it and they fully understand that. Going back to our retainer for just a minute, there are a ton of different retainers that require special clauses. Contingency fees are one that I touched on, but joint retainers are another. Referral fees and split fees are also going to need a separate clause. So you will have to include that Lori Marshall is going to be taking a percentage of this fee, or that Lori Marshall and I will be working this file together, and that the fee will be split between the two of us. So you have to make sure that your client fully understands that. And I find in business, like in anything, if you're honest, people accept it, they're appreciative, and you run into far fewer problems down the road. So if you are upfront and honest with your clients, and like Scott said, if you can lighten the mood a little bit, they're happier for it, and you likely won't run into too many problems down the road. Yeah.
Hi, we just have a chat question. Karine wanted to know what the best way to avoid potential ghost clients was, in your opinion.
Sorry, who wanted to know?
Karine.
Karine?
Okay. One of the people in chat.
With our office, the first thing we do, like I said, if somebody phones in, we tell them to stop talking. And I know that sounds really horrible, but you have to, because we have to perform a conflict check. And if we don't have an opportunity to do that, we could end up in a position where we've prejudiced one of our own clients. So the first thing we do is say, no, give me all of the parties' names. We'll do a conflict check, and then we can decide whether or not we want to have you in for a meeting. We don't take information over the phone, and if we do, it's very rare. But the best thing you can do to avoid a phantom client is to have them come in face-to-face and fill out your paperwork. They do a client intake, and then they can get a non-engagement letter sent out properly. If you're just taking information over the phone, they're gone, and then you have no idea what's going on. That's the fastest way to build up that phantom client base. Also, when you're in public, I mean, especially as a new paralegal, you get really excited and you're passionate and you want to talk about law all the time with everyone that you meet, and everyone has a legal problem, so you want to tell everyone what the solution is. Just don't, because those people will expect that they can rely on you now, and they're all going to come to you and they want your answer, and they expect you're going to be there to hold their hand every step of the way. And if you mislead them or don't show up and they think for some reason you will, you're going to end up in a lot of trouble. So as tempting as it is, just don't talk to people. That's the best way to avoid them. Facebook too, stay off Facebook. Lori's right, Facebook is a nightmare for phantom clients. You have a lot of paralegals that are giving out legal advice, and you have to not do that. And I mean, I think even I fall victim to it sometimes. You get into a debate and you're heated and you just want to get that answer out. But you really have to check yourself and rein it in, because it will put you in a position where you have 5 other people relying on your advice that aren't, they're expecting it to be valid. And maybe you don't have all the facts. Oh, sorry.
Be very careful of the groups. Just because the group is a paralegal group on Facebook does not mean that anybody can join.
yeah, there are a few groups that are not paralegal only, or not licensee only, I should say, because I know there are some lawyers in there as well. A lot of groups now have general members of the public or expert witnesses or whatever the case may be, and that person could definitely rely on your information. So just, again, just with Facebook, just be very careful what you say. As tempting as it may be to argue with people, just let it go. Yeah.
I just want to go back to what you said earlier about POA and you need authorization in this word. Does the text message count as authorization from the client?
I think that's up to the individual. I would say no. I wouldn't accept it. But I know there are times when you're kind of in a pinch that's all you have. So I don't practice in POA, so I can't really speak to best practices there, but best practice always is a client signature on a sheet of paper. So, yeah.
We have Mark Cardy, who is online, if he could just comment on that.
That'd be awesome.
If Mark could comment on a text message being an okay authorization in POA.
Paying attention.
I don't. Oh. Okay, keep going into
So yeah, we'll circle back to that if Mark pops out.
We have Tyler right here. Tyler, I'm sorry.
Oh, Tyler, yes.
Okay.
What would you do, Tyler?
So I used to do it that way, but when I watched Mr. Rick Liebman came in and he started talking about please and not getting proper sign, I had a situation where a client actually gave me the authorization. It was at midnight. I had called this guy because I had to show up to court the next day. We pled out, but it was verbal, and he was going to come back for that. Your phone, so I had to do an affidavit to prepare to see if this guy was going to report me. Turns out he didn't, but it comes down to if you don't have that signature, you're still going to have to fight through the Law Society with that, without getting hurt.
Well, I mean, they're so picky about informed consent there as well.
I think the biggest problem that's happening in POA is that it used to be, I know in my small courts, I can call up my prosecutor 2 weeks prior to, have a chat with her, have it resolved, ready to go. For instance, Whitby is a lot more difficult. It's on the fly, trying to get a hold of a prosecutor. You're showing up there that day, they're throwing the stuff out on the table, then you're trying to call the client to get that authorization. So we try to do our due diligence to try to get that authorization 14 days prior to, but sometimes we just can't because the prosecutors, they're just not getting back to us. They're not answering our emails or answering our calls.
Yeah.
But what I've been told is that although it's not an appropriate method, whatever you can get, even text message, it would help if you go to court.
Yeah, I mean, it's in writing, right? At least you have something to fall back on. I'm a have your client there type of person, so I used to attend POA. I attended a couple of times without clients. It was the most stressful moment of my life. I don't go there anymore because I just hate it.
The biggest problem with POA is they pay us to show up because they don't want to take time off work. The amount of money it's going to cost them, right?
I'm not in for that, so I leave that to you guys.
I know Barry's changed theirs though. Now they can do they actually schedule early resolution on the phone. You can sign up for that, schedule it in, which has been nice. But Whitby's the worst. It's on the fly.
Okay, I'll just say AMPS is coming. And Valerie, okay, we have Tyler, POA. We have Valerie, prosecution. Finished. Retired.
I just retired from
Gone to the dark side.
But I'm certainly here, and I'm actually thanking you very much because this is quite informative to be getting all of this information with respect to what you do to get your retainers and your file and your management, your obligations under the Law Society. And one of the biggest frustrations I found as a prosecutor in court, and I was Part 3, I'm a retired Part 3 prosecutor, and I was just recently at the Tannery in Newmarket, and I actually have all the ins and outs of the potential, the upcoming download and the impact that it's actually having right now before the download takes place. And so, the bottom line is what I was doing for the paralegals that were coming into my court, because there was just absolutely no way for me to communicate with them to coming to court. I think you'll realize in your practice that there are certain sets of charges, and they all seem to fall into a box of what you can expect the prosecutor is going to make available to you. And so what they were doing, and I was saying to them, look, I can't answer every single email and every single phone call, right? So why don't you propose the following A, B's, and C's? And if it fits within the checklist when you get here, you've already got saying, I intend to canvass the following solutions with the prosecutor. If any of these solutions are available, do you consent? And so what they were doing is they were getting the okay before coming into court, and then if they came to me knowing exactly what I would do as a resolution, and then they were ready to go and resolve on that day with their signatures. And I don't know if that violates any of the rules, but I know that that's what they were doing, and they found it helpful. So for anybody who's practicing in that context, and they have that frustration in getting the information before court, and of course you're trying to do the best for your client as quickly as possible, but it doesn't always work when the prosecution it doesn't have the resources to work with you. You should probably have a list of ideas of what it is you're looking at and work towards that goal. And if you get it, fantastic, you're ready to go. If not, then you turn around and say, well, based on what you're asking me, I need to get further instructions. You get that adjournment, and then you've got to do what you've got to do. But I think that might be helpful for some of you.
Adjournments are a whole other thing.
What do you think, Tyler?
Well, yeah, and she's absolutely right. The biggest problem that we had within our retainer, we were having to make it a blanket that basically said withdraw the charge, everybody's about the points, lower fine, and if we can't get any of that, run the trial. However, again, having Justice Rick Liebman here, when I spoke to him privately about that, and because he's more of a criminal court, he's seen agents and lawyers get up there and do that blanket instructions, and the problem is that it still leaves a gray area for you to try to do it. And I know that it's amazing to me that sometimes I can go in and deal with a prosecutor for years that's going to give me a deal that I know she gives all the time, same set of circumstances, but now policies have changed up top, and now it's a whole new thing. So we're going, okay, this doesn't fall into that blanket of what we're trying to do, and we're on the phone. I've even had called some clients, and they're half asleep on the phone, and I'm trying to say, are you awake? Are you listening to me? Are you understanding what I'm saying to you? And then
take note.
And then you try to go in, and you try to get that adjournment, and a lot of these justices, because we're short now, the adjournments are brutal to try to get them. And the justices forced me into a trial situation. I've had to stand up, and when to ask questions, I'm sorry, I don't have instructions, and I sit back down. And they run the entire trial. My client's found guilty, but I'm on the record of the entire time saying I don't have proper instructions, but now my client's going to be out a ton of money because we have to go through an appeals process. So it's just that it's a juggling game, but yeah, if you can I know in our retainer we change 14 days out, I need those written instructions, and I give them what I think is going to happen, and as long as I can finagle it into that, and they've got that signature, then I'm okay. Tight line when I make that phone call or get a text message. Because you also don't know who's texting you, right? It could be their wife, their boyfriend, their girlfriend. So that's the scary part about text messages.
Send me your picture.
Yeah, that's right, exactly. Verify your identity.
And like a selfie with a thumbs up.
That's right, exactly. Holding a newspaper with a date on it.
Mark had said that he would be wary if he was anyone else who's going to be practicing, because text and email confirmations for instructions can't check the validity of the sender. So be careful.
Yeah. I mean, it's not something that I would want to rely on, but again, I don't practice in those courts. My clients are usually readily available. I can contact them days and days and days in advance. I mean, that is a whole other thing with agency where you're taking the file last minute, but I ended up in a situation where I was lucky, my client was there, but I had taken a file at 10 o'clock the night before. That was it for me. I was done. We won. I was lucky, and I don't think that's skill. That was pure luck. So yeah, I don't touch it. It's a mess. So in your packet, you will find settlement instructions. So going back to written, this is what we have our client sign to say, my name is so-and-so, and I accept these terms, and this is a full and final, or you can adjust whatever your terms are. I've just included, full and final, including HST and costs and all of the other things that go with it. I have them dated, I have them sign it, I have a witness, it's all taken care of, and then that way this goes into their file, this gets photocopied, scanned to them. We have 3 copies of it scattered around, and I know for sure that if something ever happens and they say, I didn't say that, well, yes, you did, here you go. Here's the email confirmation, here's the copy in your file with your original signature. So sometimes there can be too much redundancy, other times it's just enough. And with something as important as an offer to settle and acceptance of that, it's just enough to have that written confirmation. So I think we're coming up to a 7. I don't know if you want to stop for a break now, Lori. We're 5 to 7.
It's up to everybody.
Do you guys want to stop for a 10-minute break and then we can come back at 5 after? Okay, so we'll do that. Stay tuned.
That lineup was cool.
Yeah.
You actually stopped there. I walked by it and went, not even going to attempt this
He's
one.
the best husband.
Way fast he's
Well, there you go.
Ex-police fire breach.
Okay, I just spoke Tyler. I have no idea.
And we have microphones, right? That's what you saw.
Mine's right here.
Okay, so we'd like to welcome you back. And during the break, we were talking about the legislative changes for careless driving. And I have a feeling in January, we might be dealing with legislative changes for careless driving in Cell. So stay tuned. We have Leanne Moore from Cochrane Moore presenting on practice management, stellar materials, and just a couple things I want to mention at the end, but fabulous presentation. We're going to start back now, whether people are back, and we're going to keep people quiet as they come back in. So welcome back, and thank you again, Leanne.
Thank you. Okay, so I'm just going to pick up where we left off. We had just covered offers, and we discussed a little bit about whether or not your offer and authorization needs to be in writing and whether text message is acceptable. I think we kind of all agreed it's probably not. So moving into final reporting letters. So I'm moving into closing off your client files. We've gone through intakes, we've gone through file management best practices throughout the ongoing matter. Now we're going to deal with how to close out the matter. So it usually starts with a final reporting letter. And again, these are drafted just with the intention of giving you a brief rundown of some of the things that should be included. I certainly would not suggest that this is exactly what my reporting letters look like, but they do include the final notes on what's happened between the interim report and the final report, whether or not settlement funds were accepted. In this case, we've said that they were. We've enclosed a copy of the check to our client. We've noted again at the bottom of the page that that's enclosed. We've enclosed our final statement of account, so again that's noted at the bottom. And if there are any funds remaining in trust, these would be returned also through this letter, and they would be included in this package. So here we've said it's been returned by a regular letter mail and email. So again, noting at the top, the method of delivery is extremely important just for your own peace of mind down the road. You'll also see in here a final statement just saying it's been a pleasure. If you have any matters in the future, please let us know. We're happy to represent you. Not every client will get that statement. Most of them do. But there are the odd ones that will just say, thanks, here's all of your information. So drafting to your client and to your client relationship is extremely important. And that's something that I was fortunate enough to pick up on at my placement. And my host was adamant that we wrote to our client instead of to ourselves. So that's something that I've taken into my practice as well. Now, I haven't pointed this out throughout the rest of it, but one of the big things with drafting letters to really anyone is your signature line. And you'll note on ours, we always have yours very truly, because that's just a nice way to send it off. You can say regards or yours truly or whatever you'd like. But we always include our firm name immediately following that, because I never want there to be any confusion as to who's writing the letter. It's always coming from my office and not from me personally. So even though it's on my letterhead and it's clearly noted, I'd like to include that extra reminder that it's not me, it's my firm. And then I have my name if someone's writing it on my behalf. Obviously this letter would be coming from me because it may include legal advice or information that only I should be transferring to the client. But if it is a letter that is, just sort of notice of settlement or a reminder email to a client, then you could sign it as a PP with the individual signature or a per, depending on who taught you. And then you'll have the individual whose behalf the letter is drafted on in caps. So in this case, it's LM, so it's my letter, but Jonathan wrote it for me, so he wrote JT in small letters. And then we've got our enclosure line. We also have a CC or a BCC, depending on who the letter's going to. In this case, it's just an enclosure. We did not joint retain. So, lovely, it's a happy client, and it's a great relationship, and everything went well. But this client, on the next page, we had to terminate. So this individual is getting a letter that's quite the opposite. In this case, we're telling the client that they've lied to us. So we had to gently break it to them that we won't be representing them. We'll be billing them for the work that we've done to this point. And we're not very happy. Please don't call me ever again. And here's your bill. So with a letter like this, it's important to outline
what exactly happened to break down that relationship. And in most cases, and we did in this one, I went to double check, we've included the rule that we're relying upon to say there's been a breakdown in the relationship. So I'm not just pulling this out of the air. I'm saying in our termination clause in our retainer agreement, in the rules of conduct, we have the ability to terminate this retainer in this relationship because you have not been truthful and honest. So we've gone through that in our letter just to explain to them why we're no longer proceeding on their behalf. And we've included our statement of account to get the final invoice paid. So,
how often do they not pay? After you send them that letter.
You know what? It's not a fun letter to write. I haven't had too many instances of it. We have had no, it's terrible.
Now, in most cases, though, would you not have a retainer already in the account, and then you just take what's there and then return the remainder?
With small claims or landlord-tenant, yes, we do. We have the money in our trust account, and then we would send an invoice and we would bill out for the work we've done. And realistically, if we've overworked, because often we do, and we're lazy about getting our top-ups, if we've overworked, likely we're writing off the debt, or we're reducing it just to say, hey, good faith, we'll just knock it down for you. Even though this relationship didn't end well, I don't want a bad reputation in the community, so I'll just knock it down, discount the price, and we'll go our separate ways. But our office also handles a lot of WSIB and human rights, so we do a lot of work on contingency. And it's actually almost always those files that we have to terminate because they've lied. So with those cases, it's really difficult because often the client is just aggressive and they're angry and it's your fault that they can't proceed, even though it's potentially a limitation issue that they've not told you about, or you get completely blindsided by evidence that they didn't tell you was coming, or their story is just complete and total fabrication, and all of a sudden you have a response that comes in that says, oh hell no. So with those cases, you're looking sometimes, we had one invoice up to $12,000 for work that was done, that was on contingency that got converted to hourly, and we came in at almost $12,000. They're not paying.
They're not paying that.
There's no way.
Especially if you don't have the money already.
Yeah, I'm not getting that.
Right.
So we sent an invoice and we, you better pay your bill, and we play tough, but it's not going to happen. So we call our bookkeeper and say, hey, we're going to have to write this off. And that sucks. It's not a fun day, but it happens, and I think in business you expect to get ripped off every once in a while, so you kind of build that into your business model. But yeah, for the most part, you have the money up front, you just invoice it out, and then you return the client file and you go your separate ways. But yeah, with contingency, those aren't fun days.
No.
So moving on, I have transfers. So this not often, but every once in a while you will also run into a situation where someone has decided that, like Lori said earlier, there's been a loss of confidence. Either they no longer trust you as their representative, or they no longer trust paralegals and they want to hire a lawyer instead because a lawyer will do a better job. So it happens. It's happened to pretty much everyone I've spoken to. We have a managing file transfer checklist. So this is from the Law Society. It's basically just a breakdown of what they want you to do. And it's modeled off of, I think it's Rule 3.1. I'm not 100% sure off the top of my head though. 3.08, so 10. And that basically just tells you that you have to return any property that belongs to the client. So all of their originating documents, any application on their behalf that they've paid for. So this is where that caveat comes in. You have a client that is on contingency that terminates you, but you have drafted their application and not filed it, they don't get it because it's work product that has not been paid for. So there are ways to kind of get some of your work at least out of it, even if you won't get the money for it. But you do have to return any original documents at no cost to the client. And you do have to return any of their applications that have been drafted, claims that have been drafted, anything that really could prejudice them not to receive. So managing the file transfer is a bit of a pain because often you're better, but you do have to set that aside. Remember that at the end of the day, it's their file, they own it, and you have to give that back to them. So be very careful with that one, because that will result in a law society complaint if you don't send them what they deserve.
I have a question. If the client does not pay, how do you collect? Mike Deloria.
Very carefully.
Yeah, so Tyler and I were just discussing this. Honestly, don't. I mean, I'm just gonna be blunt. Like, it just doesn't happen, because if at the end of the day the client is disputing their bill and you tell them you owe me $12,000 and that client says no, I don't, and you've already drafted the claim and filed the claim and they're running now off of your claim, and your retainer says you convert to hourly, and if an application is filed by us, we get first payment and right of setup, and we have every one of our bases covered, all that client has to do is take it to the Law Society for a review. Do you want to go through it?
Okay.
Because I don't.
Yeah.
We just write it off.
Okay, but if you have a small claims client, right, that doesn't pay, I have 2 claims in small claims. We collect in small claims for unpaid fees. Does that answer the question?
Cost to aggravation.
Yeah, you totally can. There's no reason you couldn't. It's just she's saying for us as a business decision, we prefer not to. What it could cost us reputation-wise in the community, the cost of fighting it, the stress, it's not worth it. Write it off, move along.
Our office ended up in a situation, like, quite honestly, we had a $12,000 debt. And we, as an office, sat down, had a partners meeting, and said, what do we do? Do we want to pursue this, risk the Law Society coming down and auditing all of our dockets and everything else? Do we want to pursue the time and energy that it's going to take to reclaim this debt? And not to mention the reputation of having sued my client? Or do I want to just say, walk it off, and next time we'll be more careful?
And the cost just to even determine if they're not judgment proof is... Well, I know with my private guys, it's like $700 to get an asset report. So even then, now you put more money out to do it, would be just, it's just not working.
Yeah, you're just digging yourself a deeper hole, right?
One thing that's a good point, because one thing you should do when you sign the client, you should, and I remember this from a law firm, we made sure that we got void checks from the client, so we had the checking account numbers.
You back that all up. But nowadays, I know I tried to do one the other day. They changed the account as soon as they walked out of the assessment hearing. It was gone.
Yeah.
So wasting your time when you could be picking up other clients.
Exactly. Yeah. I mean, for our business, we're busy enough that at the end of the day, I don't have time for that. We operate in good faith. We operate in an honest relationship with all of our clients and with all of our colleagues. And if someone is going to do that, that's not the type of person we want in our lives. So we would rather just walk away from it. And maybe that makes us stupid. Maybe we should collect. But at the end of the day, it's not worth the effort and stress that I'm going to go to dealing with that matter when I could be handling 10 or 15 other matters for clients that are paying the bills.
I know for POA it's nice because they're always going to come back. So if they bill the first time, they're going to call the second time, and you're not doing any work until you get both of it up front.
When I worked in a law firm, I had a client, but he had been a landlord-tenant client, a corporate client, skipped out on the first bill, came back because he needed help, had to pay the first bill before he got the help, skipped out on the second bill, came back for the third. We wouldn't help him until he had paid the second. He was back like 4 or 5 times, so we made most of the money.
Most of ours are corporate, so I mean we don't really
Karma's a
run
bitch
into
in this field. It'll come back to you, guaranteed.
I mean, most of our clients are corporate or union. Like, we don't deal with that very often. It's really just the human rights cases, and I mean, those people are already suffering. They likely have some sort of disability or something on. At the end of the day, I just don't want to.
Often judgment proof. So.
Yeah, they've lost their job. That's why they're coming down. With that said, we don't really run into that too often. I think that's where client management and managing your client's expectations and maintaining a good client relationship really matters.
Yeah.
So if your clients are happy with you and the service you're providing, you're likely not going to run into that issue.
You have another question there that popped up.
Is there another question over there?
Do others use promissory notes prior to finishing a file?
No.
Oh, interesting. I've never seen it in any law firms I've been in.
No, I've never touched that. I mean, likely with your cases, they're coming directly to you. I mean, even in small claims, if you do garnishment, you can have the payment directed to your office, so it's not really an issue. And the only time you run into that is with WSIB or ODSP, where they're paying it directly to your client. You're hoping the client pays you, but
I think they're referring to turning it into a liquidated claim.
Oh, no.
Promissory note, 7 paragraphs, and the claim done.
No.
Interesting thought.
No. We don't touch it because it can trigger a law society. I don't want to stand in front of a review panel and explain to you my billing structure. I mean, I know that it's honest and our dockets will come up clean. How much more time and energy is that? It's too much work. We have enough regulation and work to do. You do not have a solicitor's lien. Don't do it. It's not worth your time, and it will end badly. So, moving into our closing file checklist. So this is basically your final steps on your file. So for us, you have a few different options, really. A lot of people will store the entire file, and they keep it in a locked storage, safe, off-site. It's all noted. You mark up your boxes, you say what's in it, and you're done. Throw away the key. For us, we actually scan and shred, and then we maintain our accounting records. So our closed file storage is extremely. We have 2 electronic backups. So if something happens and that client comes back, then I can pull up their file and print the entire thing back out. But I don't need it, and I don't want to pay storage costs. So in the interim, it's all just electronic, and then it's off my hands. And the accounting, I mean, when you get rid of all the rest of it, you retain your ID and your actual dockets and accounting, it's really not that bad.
I saw a section in a subcontract the other day that I got, and I got a call into the Law Society to see if it's legitimate or not, but they had a client sign off an initial that in 3 years they're going to shred all the documents that they have with the file, and that if you require them, they need at least 14 days notice. Past that point, don't expect to get your written notice.
That's crazy.
He put that in there and the client signed off on it. So I read it and I thought, I didn't think that was...
That's crazy.
Yeah.
No, I mean, the Law Society is a minimum of 6 years for accounting. The accountants have 7 years, and there's a minimum, like, what is it, the basic limitation period of 15 years? Mm-hmm. I mean, don't touch it. Like, why would you do that?
It's your own protection.
Yeah, I mean, the only
I just do
reason
for, like, this is a firm that's quite large, and it's the amount of paper that they're storing, I would imagine.
And that's why we
just
scan
massive,
and shred.
right?
Scan and shred, I get rid of everything that isn't accounting.
Right.
If it's not a retainer agreement, a client ID, or something that's relevant to the accounting portion, which is clearly outlined by the Law Society, we get rid of it. But I scan it, and I have it on my Google Drive, and I have it in a backup hard drive as well, just in case, because you never know what's going to come down the road.
Right.
I mean, a client who's happy now could always come back, right? And I mean, was it...
Especially with WSIB, because you have such long terms on those.
Yeah, I was just thinking I was speaking with a lawyer recently, and she was telling me, she works in family law, and she was telling me that any matter that deals with a child, you have to maintain the record for 100 years. So, I mean, just keep the record. I get it, like, storage space fills up, but there are so many other ways now with like the electronic systems that you don't need to worry about that. I would never try to contract out of it.
We have another question. Mike wants to know how many deal with files through lock fees.
I think that's more like POA geared. We do retain the odd criminal file that is subcontracted out, and we do that very carefully with proper arrangements and people we trust, and we block fee them. So with those matters, it's good, but you can also run into a situation where something goes a little bit longer than you expect, and then you're eating the costs. So I don't think it's...
flat fee. It's just easier bookkeeping-wise,
Yeah.
and I don't even touch the money until the matter's done. I know some agencies will take the money and then they'll move a little bit over for doing a file or moving a little bit over for disclosure. Paperwork is just crazy, so we just throw it in the trust, we finish the matter. Well, POA is a fast turnover, right? Like my small claims ones, some of them 2-3 years I'm still waiting for money on those. But the POA, you can go knock off 15 files in the morning and you can take the money right
Lock fees are going to become much more common.
People don't like to be not knowing what they're going to pay, and that's why they come to paralegals.
Well, that's why I say, like, I think it's more of a criminal and POA thing, because in small claims, like, I would never do that.
Small
like,
claims,
as
I do.
knows, oh, that's crazy. As Scott knows, I'm sorry, but as Scott knows, like, someone hits you with 3 motions, and they want to remove you, and they want to do this, and, I mean, You
Well,
you'd be sitting in motions for.
That doesn't hit block fee. What the Law Society, and we'll do a CPD on it, there's a lot of focus right now, and it was part of the family law on limited scope retainers. And there's going to be more and more in small claims. I know a number of people who are now doing limited scope retainers by block fee.
Well, that's different.
And I've done it too.
A limited scope by block fee, I can understand. We do that as well. If you just want a defense drafted but you're not retaining, that's fine. We'll retain for a limited scope and charge you $1,000 to draft your defense. Like, that's ludicrous because there are way too many things that can come out of left field.
Yeah.
Yes. On that, I had a case, and I think you're familiar with it, Leanne. I took a case on where the client had already self-represented through settlement conference, and he comes to see me saying, okay, next step, this is going to trial. And I'm looking at it, he had a good volume of evidence, there was some research that I needed to do. So I told him, okay, I'll take this case from here to trial, we'll finish up the trial for you, for $2,000, because he wanted a price. So anyway, the opposing ended up a little bit difficult. We ended up doing 3 motions. I had to go out and do 2 site visits with them. We had 5 days of trial, and my research and all the issues that got involved, by the time I finished it, 132 hours for $2,000.
It's crazy.
So just let me address one thing about this, because block fees have been going on in law firms for hundreds of years, okay? So some of the examples of block fees, that's why we're going to do a CPD on it, because that isn't how a block fee is designed.
No.
And you do a retainer with a block fee,
Yeah.
so because the family law is coming, it's going to be really important that obviously once the Law Society does their thing and everything is decided, that block fees, block fee retainers, block fee engagements, limited scope, coaching, all of that is presented in CPDs. But we're going to wait because depending on what the Law Society says about the education and training required, we want to wait because obviously we want that to count if it possibly can be counted.
Well, we're also going to have to cover contingency fees as well because they're changing that completely.
Yeah.
I mean, there's so many new regulations coming into play with that. Yes, Scott?
Yeah, just back to what Laurie was saying, absolutely, that's going to be the key. If you're going to do block fees, and that there needs to be a block fee per task. My fault with the situation I got myself into was saying, hey, you've already finished the settlement conference, great, let me take over and I'll take it from here and finish up trial. Rather than, if this happens, it's going to be this much, if this happens, it's going to be this much. That promise or that commitment that I made to the client of, I'm going to take it from here forward without thinking through that this might still have a lot of little sidetracks that are going to go on, became the problem. And when you think about that, do the math on it. 132 hours for $2,000, I made about $7 an hour.
You have to, in the block fee retainer, you have to say, like I've done them for trial, for settlement conference, whatever, up to and including whatever. And you have to say including, not including. And your motions would be excluded. 3 extra days of trial would be excluded, and it would have been defined. And that's why I think for block fees and the retainers, the corresponding retainers, you could have a 2-hour CPD on it.
So you'll see in our retainer agreements, the one that I gave everyone today, the reason I chose this one is because it actually does include an included, not included. And you know, our standard retainer just says, like, we're not getting transcripts, we won't do a judicial review, we're not going to appeal, but it's very easy for us to turn that into a limited scope retainer for X, Y, and Z. So that's the reason I included this particular retainer for you today, so that you'd have an idea of how that could look in yours.
Having said that, we changed our retainer to the block fee. However, now we have a stipulation because we ran into it with this one lady. It was a careless trial. It was supposed to only go one day. It ended up being 4 days. And we had to say to her, listen, we billed we didn't expect. So then this is the additional fee that we charge for each day we go to trial.
Was that my referral?
Yeah, thanks, Lauren.
We do that with some of the LTVs for some of the tenants, because we work both sides of it. With some of our tenants, we'll do that because they can't afford a full fee. So we'll say, okay, well, if we can mediate, we'll charge you this much. If we go to a hearing, it'll be this much. And if it goes into multiple days, then it's X amount per day.
I find it all comes into your sales pitch too. Like,
yeah,
you're
absolutely.
just saying, listen, I'm doing the work. So I'm not trying to overcharge you here. It's very rare this may happen, but if it does, you need to know that this is what's going to happen. And if you don't want us to go to that third and fourth day for the money we're charging, well then we'll give you all your documents and you can continue on with the trial without us, kind of deal. But we run into it, especially now with these courts, the way they're doing things. It's scary.
My question with regards to using the block fees, so you're sitting out and you're making a plan. If this happens, this is you're going to be charging. This happens, it's going to be charging. The goal is, if we finish at the earliest opportunity, it's going to cost you this much. And if there's other things that come in, it's going to cost before. Now we want more money, but now you're in a trial situation. You put 2 days in, and they're not paying you another penny. But guess what? You're going to do. You're going to finish that trial.
Can you explain to the Law Society why you decided not to show up on day 2? And
No, you're going to show up and
well,
you're going to collect.
just based on the suggestion.
I would definitely show, but at the end of the day, you're not paying retainer. In our retainer agreement, it states as one of the reasons as to why we would come off retainer, one being lying. But if you don't pay us for the work, then we're going to show up and we're going to put it in front of the justice to say, we're not paid to continue on here. And
no, they'll still make you continue.
Oh, I know they will, but at least we'll have it on record.
The prejudice to your client to have someone leave what was that movie where he says, I can't continue, Your Honor, we need an adjournment, Mr. Green isn't here today? Yeah.
Lincoln lawyer.
Yeah. I think that's why I say initially POA and criminal are a lot different because you need that extra time to pull yourself off. Especially with some of the LTVs we jump into, we're not actually on record because they've already filed the documents. So unless we've done an amendment, which likely we have, we can skirt out and just say, actually. But I don't like it. I don't like doing it that way. I'd rather have the money up front in trust, bill it out at my leisure, and we'll bill you honestly, and we'll send you back whatever doesn't get used. Might be a little bit more work for me, but
from the accounting perspective, that's the route that I would recommend that you take, being that I need X number of dollars and anticipate A, B, C, D, and E. But if we only do A and B, you're going to get refunded for C, D, and E.
Right. Now, refunding can be a bit of a nightmare as well. We have one
client. The alternative
client
is not getting paid.
Yeah, well, that's the thing. I have one client though, and you only have 1 year to move around funds in trust, right? Like if you aren't using the funds actively in trust or working actively on a file, if it doesn't move in a year, you have to explain that to the Law Society. So for us, we have one client. She's like month 11. Get the money. She won't cash the checks that we send, so we can stop payment. We send a new check. She won't cash it. I think she thinks she's doing us a favor because she's like, oh no, it's like a tip. Like you guys did such a good job. Just keep that $30. And I'm like, I can't. Get out of my account. So, I don't know how we're gonna have to send her like a money order and just so it turns into a bit of a nightmare when you're trying to return funds. But at the same time, I'd rather get paid than have to deal with not getting paid at the end of the day. Because as I mentioned, we won't end up pursuing it. So,
and just on the record, never threaten your clients because it is against the rules of conduct, and never threaten to withdraw immediately before a hearing or a trial because it's against the rules of conduct.
For the paralegal, but not for the assistant.
On the record, we don't do that.
For this videotaped webinar that people will be replaying.
Well, I haven't been audited yet, so there it is now. Let's get it over with. Yes, it keeps backing out. See, if we couldn't hear what we said. So,
okay, so moving on. Our file closing checklist. So you've confirmed your client's happy, they've been paid back, you've received your final monies, you've got their files closed out, stored, everything's great. and you've sent them their final reporting letter or termination letter, the case may be. And the last thing I want to talk about is what do you keep? And like I kind of briefly touched on, it's primarily just the accounting that you need to make sure you're maintaining. Beyond that, everything else can just be shredded and scanned. But I would be very careful because you have to make sure that your client's original documents are sent back, and that includes their claims. So anything with a red stamp on it from the court goes right back to the client. And anything that's original evidence, or you even think might be original evidence because you've got some shuffling going on, return it to the client. You're better safe than sorry. In some cases, if the file is small enough, we just send the entire thing back. But usually, we're going through mountains and we scan the whole thing and then send it back. But again, at the beginning, I mentioned we don't store our originals in these folders. We actually put all original documents into a sealed envelope, or a not sealed envelope, but a sealable envelope with their name on it in the filing cabinet right away. And then that way I never have to worry about anyone hole punching original evidence or writing on it or doing anything that I can't even stand to talk about. It's in a folder, it's safe, and I don't have to worry about it ever again. Yep.
I'm just wondering, like, when you're returning client property, do you have something like a letter that says, you know, for the client to sign off that I have received my evidence back in case they come back and say they can do that my files?
Like I said, we usually send it by registered mail, so I have a signature for the registered mail. If they pick it up in office, then we have them sign to say that they've accepted it. And we usually include a list of what has been sent over. And then we have someone also sign off, just kind of almost like an in-house affidavit, just to say, yeah, I put it in the mailbox, sign their name, and then we know it was sent out. Yep.
Yeah, I've seen some paralegal offices where when they're returning documents to the client, let's say evidence, for example, they'll actually have a schedule of what's been returned, and they get the client to sign off on the schedule. As you know, Leanne, you've seen some files in my office where I'll have a few hundred pages of evidence.
Ours are the same.
So at that point, what I use is basically a, hey, you got everything, correct? And they sign off on it. If they didn't, they can't beef about it because they signed off on it. Are you okay with that?
I am in that it's, I mean, you have to do something. You don't have like 400 pages to write out every single document, and a lot of documents are titled. Like you're just making up names for them and then hoping the client understands what it is. But at the same time, I like to keep a copy of what I sent them. So what we usually do is we actually scan the client return file, and then it's labeled as client return. And then, like I said, we send it over registered mail so they get a signature on it. And then I have a full copy of what they received. And it's not just their words saying, oh yeah, I read it, and I read that 14-page document and signed the end of it. I'm saying, well, actually, this is the full package that we returned to you. And there you go. But, I mean, at the end of the day, you just hope that they don't come back, right? It doesn't really matter what you get them to sign.
Looking for something.
Yeah, I mean, it doesn't matter what they sign. If they want to come back, they'll come back. So
go away, don't come back.
Yeah, some of them come back. We like you. Yeah, the only other things that we would keep besides the regular accounting that I just want to mention quickly is the written authorizations. I mentioned earlier, like we keep a few different copies of them. We'll have the client usually sign at least 2 originals. One of those stays in the closed copy. So anything that has a written authorization or signature or acceptance or anything goes back into their accounting folder. And I just mesh it all together and put it in and slap an elastic and it goes into the closed boxes. But make sure that down the road I still have that authorization should they come back. So with your closed files, you also may run into a situation where a client wants it back. So the Law Society says that you have to give it back to them, but you are able to charge them a reasonable cost for doing that. So if your file is stored like out in Keswick and you have to drive out to Keswick to pick it up, and there's a fee for, you know, the person who lifts the 14 boxes back to your office, you can bill that to your client and say this and this cost is going to apply. But if it's just in your attic, you're probably not going to want to bill them that. And again, it's keeping that client relationship, right? Even if they're a former client, it's usually better to try to discount in places where you can, just to make sure that the client is always happy, and we'll keep sending you referrals. And I think the last thing that I want to talk about, and then I'm going to give Lori the floor, There's been a lot of talk on Facebook in the last couple of days about opening trust accounts and what to do, and people aren't really sure exactly how to go about doing that. So I've included 2 documents at the back of your packet. One is your report on opening or closing a trust account, and the other is your letter of direction for your bank. And I've included these because these are very, very important for practice management. You want to make sure the Law Society is fully aware that you have opened an account, it's active, or that you've closed an account if, like in my case, I went from an association to an LLP. We had to close out our old trust accounts and transfer them over, so we had to notify the Law Society of closing and opening. So we made sure that this letter went out. They want it as soon as is reasonably possible, and your bank must receive a letter of direction so that they know where to send the interest on your trust account. You are not allowed to keep the interest on your bank's trust account. So, yeah, unfortunately. So that's it. I'm going to give Lori the floor back unless anyone has any questions. Good?
All right, so a few things just to follow up on that. A lot of people didn't want to send out the engagement letter after the retainer. I ran into that about 4 years ago, stopped doing it. So what we did in our office, the Law Society requires that you have a procedures manual. And when I got a number of procedures manuals and made our office procedures manual, I got some really interesting manuals. And they described what the mandate of offices is. And we decided our office mandate was going to be, as far as we could, go green. So out of that manual, to make a long story short, we came up with a welcome letter. Now, it is pre-printed. It does not have the client's name on it. So it's letterhead, and then it is just starts with the body. And it's welcome to our office. It goes through our philosophy. It goes through our mandate of Go Green. It goes through what we believe in for communicating with clients in writing and in person. It goes into the different people that, through doing business with us, may come in contact with. That you might want to make a welcome letter, and then when they sign the retainer, studies were done years ago, and clients usually do not understand long documents. Or you think you're going through that retainer and they're listening to you and they're initialing, they do not understand. And the main reason for that is they block it out. They look at it, they're intimidated, and they just block it out. It happened with real estate, and it happened in an office I was in. One of the clients received in their reporting letter, and it was a simple 2-page reporting letter, and one of the paragraphs outlined instructions to the client to pull one of the forms enclosed, a Form 103. Sign it. The office had already filled it out. Send it in, and you will get your $5,000 rebate for your land transfer tax. And we had an awful lot of clients phoning our office saying 3 or 4 months later, we haven't gotten our land transfer tax refund. Well, pull out your reporting letter. Yes. Is the Form 103 in that? Yes. Well, it shouldn't be. You had to send it in. If you read paragraph 2 of your reporting letter, and shortly after that, it so happened that this study came out that our clients do not understand. So we have
Oh, they're the fold-up folders. I buy them when they're on clearance. And they get a copy of the retainer, which I can guarantee they never read after I hand it to them. Then a copy of the receipt, copy of their verification of identity, and so on. But they also get a copy of the welcome letter.
I should mention, we do that as well.
Yeah. So our welcome letter is in there, and it's one page, very simple. The young people love Go Green. They just love it. So that's how we combat not having to do that engagement letter. And every client gets it, and they love it. We have received tons of compliments.
We were doing the folders. Intakes outgrew the folders, like we're flying through them. So we ended up just giving the client intake form with the letter, and then they can take that home with their retainer. For larger clients, corporations, they get the fancy packages, but the regular clients don't get those anymore, which is bad. We should.
Buy them on clearance. I got them for 3 cents.
Yeah, we also include $1.20
No. Regular 25 cents.
Yeah,
We'll
no,
talk.
we have the fancy ones, but we include their privacy in it, and we include the paralegal rules of conduct, and we include
You include the paralegal rules of conduct.
a reference to it and a reference to the Law Society
Okay.
directory and complaint process.
And
So they actually get all of the information up front. No, we do, because honestly, at the end of the day, it's their right.
And we also cover the areas that we do in our office, because if somebody comes to Leanne for LTV, they're going to remember Leanne for LTV, but they might not realize that we have other areas.
Good
Our
one,
welcome
too.
letter
Yeah.
It's as much for them as it is for us. It's a little bit of ad work in there as well.
Yeah. It's advertising and marketing.
Yeah.
Okay. All right. This is really important. And I'm a stickler for corporate law. It's my favorite area of law. I worked in it for many, many years as a law clerk. With the new condominium law, and I'm not getting into substantive.
It's so exciting.
It's so exciting. For paralegals, that's an area that wasn't mentioned with the Friday family and contingency and officer of the court, and then Tuesday, debtor, construction lien, and then new condominium law. So lots of areas.
That came out November 1st.
November 1?
November
Okay,
1st.
I missed that.
Yeah.
However, condominium law and practice. And I have over the years, and I just stopped, referred it out, all of my clients to a couple years ago, I think, to one of the paralegals here. When you are working in condominium law, obviously you have to know condominium law, all right? But if you are working for a condominium corporation, you will have contact with the practice manager, or the property management company. That property management company has all of the information about the directors. Condominiums and cooperative housing developments have drama, okay, on their boards of directors. A lot of drama, okay? There isn't one that I have come across that does not have drama. So if you have a board that is appointed for a 2-year term, chances are in a cooperative housing development or a condominium corporation, the directors are not going to stay for that 2-year term. So what is going to happen is, Leanne, perfect precedent. Josh? Sorry. Oh, sorry, the microphone is picking up everything you do. You might want to sit at another table. Sorry. People's ears online might be going bang, bang, bang. Sorry.
Sound of Leanne drinking.
Yeah.
Yeah,
maybe we'll move.
No, it's okay. I'm not going to move. I'm not going to move. Got it?
Thank you. Okay, so for condominium corporations, what I learned to do is you have an authorization, the board of directors authorizes you to speak to the property manager who is responsible for the condominium, whatever number it is. And that property manager, you're going to follow up minimum every 4 months, minimum every 4 months, to get a new list of the directors
And I challenge anybody to present one that for a full 12-month period, the same directors that started are the same directors that ended. And the important thing with that you've got to know is those directors, they're, like Leanne said, you've got their, on the verification of identity, you've got their ID. Well, if they have resigned and then a new one come on, here you are thinking, okay, we're good, it's a 2-year term. Well, no, you got a new one that came on. If you don't have an up-to-date list, and I had one that there were 7 directors, went down to 5 directors, and then 3 or 4 of those directors changed. Luckily, my property manager, back then I dealt with about 30 of their properties. He contacted me and said, our directors have changed, no decisions can be made. And then I was able to update everything. So you have to be very, very careful. Paralegals aren't taught corporate law, and it's a very good idea that you, I don't know, if you're going to do condominiums or cooperatives, anything with a board, you should take the Institute of Law Clerks of Ontario corporate law course. I think it's available online. It's 4 months, or you can take it in person at the community colleges, and you should, it's substantive. It teaches you everything about business structures and corporate law. So in law school, I know because I used to train articling students, they train you, all of this stuff about corporations and all the case law and everything, and then the articling students come in, and I say, okay, this is what you're doing. If you sit down here, I'll go through it with you, and 99% say, oh no, I come from law school, I know more than you, you're only a law clerk. Fine, go do it. They come back 4 hours later because they have no idea what a Form 1 and a Schedule A are. Well, in accordance with the OBCA, Section 112, that is required. They didn't teach you that in law school? So that's what, no, you don't. Our jobs as paralegals, in my opinion, the rules of conduct say we are supposed to make ourselves competent. And this was an argument with family law. And I don't disagree with it, but I knew it wouldn't fly. That we are responsible for making ourselves competent, and therefore they should just put family law in, and whoever wants to do it is trusted to make themselves competent. I would put it out there, how many paralegals are representing corporations, are representing any entity that has a board of directors and knows nothing about corporate law. That is competence. And I'm just putting the warning out there. If you make a mistake, and if I had on that one file where all of the majority had changed, and if I had a $15,000 settlement accepted, and if any of those directors in the majority, if I hadn't been notified of that, I had previous authorizations, I had 2-year terms, I had everything I needed in the articles, I had everything, I had the resolutions, I had everything. Didn't matter. I would have been, they couldn't have collected, right? So then, who's the Law Society complaint going to go in against? Me. Then the Law Society says, didn't you know? You should have checked. Well, no, I didn't. I don't know corporate law. Okay, so we're going to discipline you publicly for competence. And I will tell you, Scott has his hand up, and before you even speak, I will say, I am not competent in directors and officers' liability. And there is not 6 months that go by that I am not phoning Scott and saying, all right, I think I've got it this time, but I'm running it by him because he was an insurance broker and
directors and officers liability. There's a difference between D&O and E&O. Yes, I had an insurance license. Mine didn't focus on D&O and E&O. Okay, too many areas. Talk to me about auto. Scott and I'll talk about that. Home, fine. Life, but not D&O and E&O. Scott?
A couple moments ago, you mentioned articles, resolutions, and so forth. And one of the things that scares me is the number of calls that I do get where somebody has a corporate client. It is a corporate client that has a board of directors, usually a non-profit. Smaller mom and pop type businesses, they're incorporated, but you usually just have one primary decision maker or whatever. But I'm finding with the non-profits, so a paralegal will take on a non-profit association as a client. You run into the issues that you're talking about a moment ago, and you use the words articles and resolutions. And how many paralegals out there will have that type of client and they don't know what you just meant when you said articles?
Or Form 1 and Schedule A. If you don't know what a Form 1 and Schedule A is, good God, don't retain a corporation. Yeah. Like, you are not competent. Period.
Oh,
you're not.
Before you finish up,
yeah,
I need to mention that everything that's managing can be found in Bylaw 7.1.
Yes.
I have to mention that. So,
okay.
Yeah, if you're looking for information on practice management, Bylaw 7.1. If you're looking for trust information, Bylaw 9.
Okay.
Okay, good.
7.1 and Bylaw 9. But yes, exactly. So corporations, be very, 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 very careful. And Institute of Law Clerks, I'll tell you, I've written those exams so many times just to make sure that I'm fresh. And the courses are quite inexpensive. And there are 4 of them: real estate, corporate, wills and estates, and civil. And even for small claims, the rules say if the small claims rules are silent on something, you defer to the rules of civil procedure. How many paralegals are competent in the rules of civil procedure? And these are things that you can take courses in. And the Law Society is okay with us learning the substantive aspects of real estate, of corporate, of wills and estates. They are not okay with us learning how to probate an estate. Okay? So that's the difference, and I would advise those. Okay, signatures. Signatures on letters, and I ran into this in law firms. If you have any letters going out from your office that contain legal advice, a non-licensee may not sign. Must be a licensee. Okay? But if you have a letter going out from your office that says, please find enclosed our interim account for the time period from here to here. If you have any questions, please call. Your assistant or a law clerk or a non-licensee can sign that letter. That person's name can be typed in the signature line because it does not contain legal advice. Anything containing legal advice, then a licensee has to sign. So that was another thing. Okay, so reporting letters. How many people, and I'll take hands in here, webcast can participate by chat. We have a big screen. How many people in here know the theoretical significance of a reporting letter? Okay, I know why you do. Okay, how many people in here, paralegals, send out reporting letters? Okay, so you should know the significance of a reporting letter before you're sending it out. So, and there are interim reporting letters and final reporting letters. Okay, they are required. I don't know if it's the rules of conduct. I don't know. It's got to be the rules of conduct. Now, the rules of conduct are ambiguous because they say You may not transfer trust funds until a matter is completed. Okay? And I've dealt with this with lawyers and the Law Society in detail, because what is the definition of the matter being completed? Okay? So you have a 2-year small claims case. You are not going to take a retainer in the beginning and not take out any money. So you are going to be doing interim reporting letters. Okay? And with every interim reporting letter, you're going to state to the client what you've done. So, since our last report, as you are aware, we attended settlement conference with you. We confirmed that the matter was not settled. And you're telling the client exactly what the client already knows, because the client was there. And then you are including your interim account. At the top of your interim account, it will say interim account. I don't share, I understand 100% fear of the Law Society. I do not fear having a bill of costs or an account examined.
I don't fear it either, let me be clear. Our docketing and timekeeping and invoicing is very, very, it's up to snuff. We would pass, I'm not worried.
I know.
I just don't want the hassle. I don't want to have to deal with it. I have other things to deal with.
There's a lot of intangibles at play there to go into that decision.
Examination of a report or a bill of costs, probably, I don't know, 2 hours?
I don't have 2 hours to give to that. I'm sorry.
When I contacted the Law Society, they said that it could be up to, like, they could actually come in, review all your files in the office, because if it's a contingency being converted to hourly, there's an extra level of investigation that they put into it.
Okay, that's not what I'm talking about. I'm talking
That's
about
what she was talking about.
That's what I was talking about.
Oh,
when
no,
I was
no.
speaking to
No.
that.
Okay.
When I talked about interim, it's on
Yeah.
it's on the reporting letter that I gave out. There's an interim reporting letter with a statement of account enclosed,
Yeah.
and the final reporting letter with the statement of account. You'll see
Yeah.
we've completed this and done this. And
Exactly. So your interim reporting letter is telling everything that you've done, and then your account is an interim account. Get your money out of trust. Now, I know there is someone here, and I forgot the document, but I will pull it up and send the link, I promise, and you'll know who you are, to the trust reconciliation sheet that must be done every single month, okay, on the trust account within 7 days. Okay, and I know there's someone who needs that, and I will pull it up.
And I understand the reporting letters are done with the intent of releasing your funds from trust.
3 years.
And that's fine. With our office, because we do a lot of work on contingency, we actually send reporting letters almost monthly to some of our clients. And often those reporting letters are just saying, nothing's happened, keep waiting. But it's because we want to make sure that we're maintaining a client relationship.
And that is perfect, because you want to be contacting your client before your client contacts you. Except the one I'm going to fire that contacts me every single day, 3 times a day. But that one is another story.
You have to live faster.
Yeah, okay. So I'm taking out contingency from this. We're talking POA, we're talking small claims, we're talking landlord-tenant, we are not talking contingency. Because, like Leanne said, she was responsible for submissions for OPA on contingency, and there have been a lot of changes, but there were no caps put on. So that was, to me, it's successful.
That was a victory.
That was really good. So when you're sending out an interim account, you want to get the money out of trust, but you want to be able to justify how much you're taking out also. So, and I should have brought it and had it available. The reconciliation sheet, the trust reconciliation sheet for every client. Yes, I do like trust accounting. I just do.
That's why I love it for you.
It lists the clients that you have money in trust for, but it also, you must list changes that happened. And what Leanne was referring to is any change that hasn't happened in 12 months, you've got to do considerable reporting on the annual report. So therefore, you want to make sure you do those interim reporting letters to get that money out of the trust account.
And to get more in.
Pardon?
And to get more in.
And to get more in, yes.
People are going to be much more willing to give you a top-up when you've explained where that money went with detail. If you're just saying, well, the money's spent, give me more.
Yes.
You might have a problem.
I'm sure Scott's had situations, I mean, we have in our office where we say we need $1,500 up front, and 2 weeks later, we're already drained. And it happens, and I mean, sometimes reporting letters go out as frequently as every 2 weeks. Most of the time, it's about once a month. But yeah, we do it with the intention of keeping our clients up to date so that we aren't inundated with emails and phone calls about what's happening. And Colin's fantastic with that because he works WSIB, so his files take forever to turn over. But monthly, he's sending his clients a letter to say, hey, you know, I sent 1 fax this month and things are chugging along.
You're better than I am.
He's great. He's far better than any of us.
You say you don't have time for that stuff. I don't have time for that.
With WSIB, though, and HRTO, there's a lot of hand-holding that goes into it.
Tell me about
with HRTO, the delay that they're experiencing now, just with actually accepting your application and forwarding it on and serving it, the delay is so long that if you're not sending regular updates to the clients, they're going to think you forgot.
Yeah. That's a good point.
I think you have a question.
I should start doing that. Question?
Is there a question up there?
No. Someone just wanted to know what Lori was writing down, so we were just typing it out for them.
Oh, what I'm writing on here? I'm sorry, I thought everyone could say it.
It's okay.
Interim, INTERIM, star, final, star.
We got that, don't worry.
Oh, did you? Okay.
Yeah.
Okay, sorry. So, final bills, and this will to your block fees also. Okay? When I was doing a lot of small claims, I found block fees were way easier. Way easier. Limited scope retainers, block fee. I made a lot more money, and I would tell the client, I will represent you up to and including settlement conference, no further. So there was a block fee for this, a block fee for that, and yes, I put what's not included. These things could come up, okay? And then, very easy, take the retainer in. All of my students and graduates know my philosophy. There are very, very few clients that don't get a refund. Okay? So there are very few of my clients that don't get a refund.
It's such a headache.
Meaning, I will take in a retainer of $750. Okay? I know the work is worth $750. So I up the retainer to $775. Send the client back $25.
And then they don't cash the check.
No, my clients cash the check.
I've always done it where I get a bank draft and I send them with a letter.
Me too.
Because I'm not going to have them wait.
That's what we're doing. That's what we had to start doing. But I mean, now in our retainer agreement, we've included a clause, and I don't know if it's the one I gave you guys tonight. It says, if you have additional funds, it will be returned by money order, and that will be counted as a disbursement. So now I'm billing you that $10 that I have to pay for the money order. Scott?
So, sorry, tell me how you're doing this, because this has come up with me
it's annoying.
as a problem.
Yeah.
Where I send somebody, $12 as their final trust check when I'm closing the file out, and they don't cash it.
They think it's a tip. Look, you did such a good job, Scott. I'm going to let you keep that $12 as a tip. It doesn't work that way.
No,
it costs me more than $12 to have to deal with the fact that they didn't cash it. $12.
It costs us $7.50 to send out the draft. We send it by draft.
Yeah. So
it clears our account. I don't like business accounting. Okay? I like trust accounting, not business accounting. So I want everything to clear that account immediately. I don't want to reconcile the account at the end of the month and have outstanding checks. Okay? So when I do that refund, I have always, and the fee is up to $7.50 from $2.50 26 years ago. So it has gone up 200% in 26 years. That's a lot. You got to admit. So, anyways, I send a draft. The reason I do, and this is full-time POA, and the way I'm seeing it with family coming in, I'm going to be full-time POA and family again. That's how I see it. One sec. So, POA, I take in $350 on a $300 case, send $50. My clients...
Actually, I've never, ever sent a refund for POA.
Yeah, but I've taken the extra money in the beginning
in
order to send the money, because the majority of my POA clients were from high schools. So, and they don't know what a paralegal is, but they run around their saying, my lawyer sent me $50.
Oh, you are just,
Okay?
You are just great.
Exactly.
Promoting
But
yourself.
what they don't realize is it's their money I'm refunding. No. To them, I've sent a bank draft for a free $50. And they're satisfied with the case. So that's exactly how I did it. And I'll tell you, plus 5 business cards in the letter, and I was full-time, very, very, very busy and lucrative business. John, sorry.
What would you do with the bank draft if it came back undelivered?
Oh, if it came back undelivered?
Because that's closer to the issue. we've
Redeposit,
experienced.
void. Accountant deals with it at the end of the year. I don't deal with that stuff.
Yeah, so Scott,
that's business accounting. I don't deal with that. The accountant deals with that.
So Scott, what we did was we included a clause in the retainer. So now in our retainer agreement, we tell them we're returning by money order, and then that's a disbursement that you will pay. So we will deduct that from the amount that you'll get returned to trust. And then it's gone. But I send it for my general, and then after it's done, I transfer it out of the trust. So if it bounces back, then yeah, I let our accountant fight it out.
Yeah. At the end of the year, they just do it. Honestly, it's not hard.
And most people, for us too, when you call them and say, oh, by the way, we're sending you a bank draft back, they're waiting for that envelope to come in.
Oh, you're not kidding. And usually
Right.
it's going registered mail anyways, because I'm sending original documents.
Right.
It's in the final report, right? Or if it's small claims, I'm finishing off the block fee matter. And very few small claims have not resulted in the people saying, oh my gosh, I don't have any representation now. I want to retain you for the next step. And this is how I see family going. They are really, really, really emphasizing the coaching and the limited scope retainers. Yeah.
We've done.
Pardon?
We've sent EFT from our general account to the people, and they've accepted it, and the paper trail's there, and it's just easier that way too.
We do a lot that way as well.
EFT is a wonderful thing.
We have one. We just have this one client that just does not want their money back. Like, it's killing me. It's like $37.
Really?
Take it. I'm gonna start billing them for like every letter I have to write.
EFT I don't do. Only because, again, because that's business accounting. I don't like
No,
business.
it's not. And nowadays, especially with the millennials and the young,
all
it's
on
like
their
all on their
phone.
phone.
Oh yeah.
And I've had it where I'm standing outside of court, and I'm going, I'm about to walk in. He's hit this, and then it hits the account. I'm sending your money.
Yeah.
And then you're good to go.
And then you're good to go.
You can't do that. We have a prosecutor.
I mean, we don't
not anymore. Oh, retired. Okay.
The
That's
email,
so much better.
The email money transfers I was a little bit wary of, but I looked into it under the bylaws, and they are allowed. I mean, basically the Law Society says be careful. But
You're
as long as they
paper
have,
trail.
they have
'Cause
the
you got
reference
the email,
numbers,
you got
the
the
dates,
number kit, yeah,
everything.
it's fantastic.
Everything you need. They have a
100%.
timestamp for the second that it deposited. They're fantastic.
I don't adapt to change well.
I know.
10 years.
So the other thing
Well, if
that
you're
I
getting
wanted
back
to
into
talk about,
POA, Lori, you better step up your technology game.
Lori, I actually misread the clock because I am not that bright. So I actually gave over an hour early. So I apologize because I don't think you were expecting to stand up and talk for an hour. But we
She's
didn't
good
talk
at it,
about ticklers because I cut them out because I didn't think we had time.
Okay. Why don't we talk about Leanne and I can tag team it. Okay. More important, let's talk about conflict of interest.
Yes.
Okay? And let's, as a group, participate in the discussion. And, okay, I'll give you, work with the people beside you. I'll give you 5 minutes, come up with an example of a potential conflict of interest. What is a conflict of interest? Okay, so 5 minutes, 20 after. Tyler.
We role play all day long in court. Why do we have to do it at CP?
I tried to talk about Chick.
Want to put on a show.
I didn't win. Like it was up and down, but I won. I didn't really win. So it's like you don't want to. I did play some poker. I only did a couple spins of roulette. I have more of a lot of that, but I played most of the poker. And then some
Our office is
yeah, we rented a car while we were down there. Drove around like so crazy. Damn. How many people? I just my dad. Yeah, I never really like that since I was older. Yeah, it's kind of more like yeah, a lot of good restaurants.
Here's a conflict. I'm sorry, I seriously
Oh, the whole thing. Like, I don't know. You could do it pretty reasonably, like $3,000 or $4,000. Depends on how much you want to spend it. So, if it wasn't very much for the hotel, yeah, but I'm saying like the whole thing.
I totally could have
played your hotel. That yeah. Once you add in the gambling, that's what I was saying. That's what I thought it'd be better. I'm sold.
Okay. When I got to the level,
Now you can go there and do it. It's not the place you want to go right now. Like you want to be.
Well, we find out after.
Oh, okay. So that's my number.
I'm going to get one.
I would say is property managers. That's the one where more frequently than anything else you got to tell people shut up, stop talking.
You probably do it all for thousands.
Hi, I live in this building and I have an issue with my landlord. Or I have stop it.
By the way, if you guys know this, I guess like you didn't want to stay.
No,
you want
to stay somewhere nice.
But I think we're $1,000.
That's what I'm guessing after like ticket, food, car rental, like everything we spent down there.
And our union rep too.
What kind of car you renting?
I haven't
had like a new Chevy truck.
No, but it's been one of the areas that we've had to be the most cognizant towards with my HRTO stuff, just to make sure that I'm never.
Oh, I got it a long time ago. I was on the first. Yeah.
So this is the view from the hotel room when I got in. So that's
Lori and I were discussing what we're
looking
employing.
out, that's the Bellagio right there.
Whether or not it's a
Palace across the street. And that's the Mirage. Here.
I'm of the opinion.
This is all stripped.
Turn it away. I was working all this time, you know? It was bad. Yeah. Did you got your license? No, yet?
But she has some.
I'm gonna go for a quick snowfall.
I still feel like conflict as far as it might just be something where you can be breaching your confidentiality agreement.
And I know
but I still feel like that wouldn't be
my session exam in August.
Okay, we ready?
There wasn't a lot of people there.
Oh, that's a good one.
What is it? Domestic assault, one party calls conflict. Domestic assault, one party, both parties charge, one calls first, second party calls second. Definite conflict.
Oh yeah.
100%. Okay, did you think of any? Okay, Val?
So my default button goes back to
Okay.
used to do.
Okay.
For for me, from a conflict position, and I'd like to invite comment on this, because I was always of the opinion that where there were co-defendants, they should each have their own representation. I mean, you have a single paralegal showing up. How do you represent the best interests of two people, both charged under the same set of facts, and represent them both to the fullest of their best interests? I think there's a conflict, especially because I've been in trial situations where one begins to sell the other up the river. And when you get in that situation, how are you representing them both to their best interests? Because one's evidence, because in any trial situation, I challenge anybody to say that you will know in every trial situation exactly what's going to be in their mouths. You can prep them until the cows come home, and you're always going to get something on the stand that you didn't anticipate. And that's what my position has always been, that that shouldn't happen. I'd like your opinion on that.
I don't want to give my opinion on that.
No one does.
Are you talking about co-defendants testifying against one another?
Well, no, I'm talking about when you get into a trial setting,
right?
Okay, and if the single paralegal has been coming in for appearances, I'll give you an example. You're dealing with liquor license act charges against a bar, and so the corporate defendant's charged, the human defendant's charged, the manager is charged. Okay, so you have all of these, and one lawyer shows up, and I was dealing with one in particular where we were talking about a fatality. And that is somebody drank to the point of intoxication, went to go home, nobody took care of them, fell asleep in a snowbank and froze to death. All right? And you can't have every single human defendant represented by the same lawyer. And yet they will come in and say, yeah, I'm doing it up until the point of trial. But in a trial situation, I think every individual human has to have their own representation. And I think that is where the conflict lies, but I've seen it happen. That's why I wanted anybody else's opinion on it, because from my perspective, I wouldn't represent every individual person on information. I would say, I am here for so-and-so. I can be agent for party B and party C for the sole purposes of saying, I'll give them the adjournment date or so forth and so forth, but you cannot give them legal advice and have them act on it and give the other co-defendants legal advice. I believe that is a conflict of interest. I don't know what somebody else is doing.
They're not forced to testify though. Like they have the choice, right?
That's not what I'm talking about. I'm the legal representative. There are 3 human defendants. All right. Can I give all 3 of them independent legal advice? I say no.
Well, I mean,
it happens.
We do join all the time.
Go ahead.
Scott?
Yeah. Valerie, I agree with you completely. You're from the POA background, I'm from the small claims background, so I have an example similar to yours, but I'm going to address yours first, and then I'll throw out my example. It basically makes the same point. I agree with you completely on that, because how is it that one representative can have 2 clients and from day one already know that, hey, as I learn more about this particular situation, I might find out that it's in your best interest to throw her under the bus. And if I retained both, be defending both, how in the world do I ever get into that situation? Or why would I allow myself to get into that potential situation that I'm going to either from day one know that you should be throwing her under the bus, or maybe even vice versa? Or that it might develop into that. So I wouldn't want to get into that type of situation where I have joint clients in the sort of scenario that you're talking about right now, that they may need to throw each other under the bus. I had a situation in small claims very similar recently, where a general contractor and a subcontractor had not been paid. Now the general contractor, so he had done, it was an HVAC project, he had done some work for a homeowner. He hadn't got paid, so he decided, well, I can't pay my subcontractor then because I haven't been paid yet either. But don't worry about it, subcontractor. I'm going to sue and I'm going to get us our money. So he sues the homeowner and he names himself, of course, as plaintiff 1, and he names the subcontractor as plaintiff 2 things start to go astray when there's counterclaims coming back from the homeowner saying, hey, there was a screw up with this, there was a screw up with this, so the reason I haven't paid my debt is because there's all these defects. At that point, the guy comes running into my office saying, hi, I need you to represent me and my buddy, the subcontractor. And I'm looking at the situation going, subcontractor doesn't have privity of contract with the homeowner. He's got privity of contract with you. If he didn't get paid, he needs to be suing you. So now I got this problem of, I got two clients that sort of walked through the door, and one of them needs to attack the other. And so I had to tell the subcontractor, you need to go find your own representation. I'm in the awkward spot of, how do I tell him, you need to find representation. The client that just, the primary client that walked through my door and that made all the initial contacts and thought he was helping his buddy and that they're both in bed with this this claim, he really needs to be suing you. So it was a very difficult and awkward situation to need to backpedal out of, because at that point I have to ask myself, can I even represent either one of them? Because I'm now having to, now that it's become clear who's involved and what's going on here, and can I even take the general contractor? Because I'm now looking at something where I'm telling my client, hey, hold on here, I got to tell your buddy that he should be suing you.
And it doesn't appear that the courts call the conflict. It would appear that the conflict is called once there is a Law Society complaint.
Okay.
And then the Law Society says there is conflict. So that appears to be what happens. And I know because I had a potential one 5 years ago now, and I'll never forget it. And I asked myself, do I know the specific modus operandi of the company that I'm going against because of the relationship I had with that company, their trades? I didn't. So I represented. The court did not call the conflict. However, what if they're right? That's what it came down to.
So I have two. First of all, we run into that like every day because we represent human rights and we sue the manager, the supervisor, the coworker, the company, the individuals who own the or shareholders in the company because they're personally responsible. I mean, we go after everyone in human rights, and then we have one lawyer.
You have one.
We
client.
do.
Yes.
You have but the other side.
You have the client.
But,
No. But we work both sides. Okay, so we often are in a situation where the employer comes to us and says we're getting sued, and all of these people are getting sued, and we represent all of them.
Okay.
And it happens almost every day where we send out a claim, and opposing comes back and says we're representing everyone because vicarious liability jumps in, and they say, well, the company's responsible at the end of the day. So I get what you're saying, and then who do you represent? Where does that conflict end? I think that's something that you have to take up with each individual case. I don't think it's something you can broadly say this is always going to be a conflict, because often it is pretty clear cut who is going to end up being responsible, and if everyone is in agreement that this is how it should go, then you're not going to be crossing any line.
That's an important lesson for anybody who's thinking about taking on multiple clients, that they have to consider at what point what is the potential for a conflict of interest, or can they do it? It's not just carte blanche that you can do it.
Right.
And I think from this discussion, that's what we can take from it. But I do have another example that I thought might be interesting, and I still want your opinion.
It's good because you're from a criminal and POA perspective, so that's good. Just one sec.
Yep.
Do we have anything on that?
There's 3 examples that
3. Okay. Domestic assault. Both parties charged. One party calls first. Second party calls. Absolutely. Okay. 2 siblings with the same charges from provincial regulator or municipality. Okay, so, but are they co-defendants? Because what you're saying is majority would represent the 2 co-defendants.
An
right?
example for that, 2 siblings with the same charges from a provincial regulator or a municipality. An example again would be that common under the Liquor License Act, where you get brothers who own a bar and they're both being charged.
Yeah.
And for fire code violations, for failing to comply with their duties under the Liquor License Act to enforce all other regulations. It's such a broad umbrella. And then they're quoting that the exit signs weren't lit up.
He filled in though and said no co-defendant.
Two siblings with the same charges from a provincial regulator, then are we talking about two different charge events or one charge event and both charged?
So would that be an example of, I don't know, two brothers gone out B&E? So now we're being charged with breaking and entering here and breaking and entering here.
Side by side, individually owned by each brother.
Okay, two houses side by side, individually owned by each brother, and the municipality comes in and gives them work orders. That would be a more appropriate example. Those are two separate events because they're two separate work orders. Now the question you're asking, I think they're asking is, can I represent brother A and can I represent brother B? Well, they're totally separate claims, and if you've never had any conflict with them before, my answer to that would be yes.
Well, and the interests of one aren't averse to the other in that scenario, right?
Absolutely.
Brother A doesn't have to harm Brother B. I think it comes back to what Scott said, though. You can debate the specifics of anything, but you have to try and anticipate from the scenario or what details you do have. How likely is it that their interests are going to diverge, and you're going to be found where person A needs one thing and person B needs another? If you're looking at the matter and you say, I can't imagine a situation where they're going to want different things or they're going to need a different course of action, you're probably safe.
I mean, we discussed it at the beginning as well with joint retainers and sitting down the importance of having them initial next to, yes, I understand if a conflict arises and we disagree, I have to step in.
Advise both parties, you tell them to seek ILA and you back off, right? And that's if it's something unanticipated comes up that you just couldn't think about in advance, right? Because it happens.
The scenario that I was thinking, though, the one that I wanted to actually raise, is that I'm going to throw Colin under the bus. Colin represents unions. So he doesn't represent the union in that he is writing their agreements. He represents the workers of the union. So the union says, hey, Colin, you need to go and meet with client A and B and C and D, and then Colin goes and does all of that. And he runs into a situation where what happens if client B says, I want to sue the union?
So, the union would be footing the bill for me to work on behalf of their members, and I would have, there's a whole different set of conflicting retainers and everything that goes into that, but bottom line is there an instance where the interests of the client and the interests of the union are going to diverge and become opposites? So when they start out, the union wants the WSIB claim adjudicated, and so does the workers. So that's all well and good. Potentially, lots of times, HR claims can come up if the contract acted in bad faith or it was a bad layoff or any number of things. But the issue with the union can come into play where the union has the duty of fair representation. And if they neglect that, then the worker might have a cause of action against them. So if it comes to light that the union hadn't done their due diligence or acted in poor faith, I would have to advise the client that you have a potential claim against the union, and I can't represent you against them. I recommend this person, and I back away. But by the same token, I'm also employed by the union to stop those instances from happening and say, hey, if you guys don't do this for this guy, you could be open to that duty of fair rep claim. So I suggest you do this, and then they will pay me to do that, and we avoid that situation. But it could potentially arise that way, right?
Yeah. What's important in a circumstance like that is when you are hired by the union to do the union work on behalf of their union member, from the get-go, they need to be aware that you work for the union and the union's best interest. And at the point that the interests are no longer consistent with each other, you can, because what will happen is you now become the party to their complaint.
That's right. And that's not only that's in my retainer, it's also in a separate letter, disclaimer, I see why 10 different ways on that.
Are you open to share that retainer and how to do it?
Absolutely. I can put that on the group or send it to Lori.
I would be very, very interested.
We're very careful with them because we actually spoke with, I'm sure everyone knows Mike Benoit. He was a fabulous resource when we first started retaining unions because we hit this and we went, what do we do?
And the wording is somewhat ambiguous in the rules, and as far as around joint retainers and how do you notify people and get that independent consent. So some of it's ambiguous, and I just wanted to make sure I was doing everything absolutely possible. So we've consulted with Mr. Benoit.
Best practice, always find a mentor. Always. It doesn't matter how long you've been practicing. If you hit something you don't know, someone else has probably already hit it.
call, find someone who can help you, because there's always someone that's been through this that can walk you through what to do.
And there are clauses in the rules that speak to which circumstances a third party can pay the legal fees of another party, and it all revolves around informed consent. The person has to be well aware of who's taking care of their bills. It can't just be a shadowy figure. Or
One last question on your particular scenario. Do you advise the clients at the point that you get to a negotiated settlement that they have the right to get in representation before signing anything?
like in a settlement.
So we have a union member.
Yep.
You have been retained by the union to represent their interests. You reach a settlement, all right? But you are acting for the union because it's in the union's best interest to get this settled. And then there should be a clause that indicates that they're completely satisfied with their union representation. Otherwise, what happens is if they walk away and find out 3 months later that they got railroaded and they should have had a better settlement, and did they get the opportunity? Did you advise them to get, okay, here's what's being offered. You have the option of getting independent legal advice. 9 times out of 10, they will say, no problem, I'm happy with this, I'm willing to sign it. Every one of your memorandums should include a clause that they were satisfied with their union representation.
A waiver of ILA.
With the HRTOs, we have them sign off a separate authorization. With WSIB, it's not so much settlements as WSIB grants an award.
Yeah, I agree.
So, I mean, with WSIB, they're just ecstatic that they've actually won. So
But there's no back and forth as to the amount. It's the tribunal awards what they award.
Yeah. So we just send them a letter saying, I'm sure your $8,000 check you just received that you didn't have to pay to get, and they go, yep.
I was more interested in the specific when you're dealing with the employment law issues with respect to unions as your clients.
Yes, for anything that evolves for like an HR context or employment, absolutely, absolutely disclaimer. Just not as it applies to WSIB because you don't run into that particular
CPP as well. We haven't had any issues with CPP either.
Scott,
yeah. Bursting.
On the issue of it, ILA, make sure it's ILA.
Yeah.
Mm-hmm. Independent legal advice does not mean, and believe it or not, I saw the situation. Husband was to go get ILA in a real estate transaction. The wife was a real estate agent. The husband knows nothing about real estate. They're buying their first home together. And the real estate lawyer that was handling the transaction was the lawyer that the wife's real estate agency deals with on a regular basis. And the contractor, the mortgage was being set up where the hubby was the guarantor of the, he didn't know what he was signing. He's becoming the guarantor on the mortgage. Title's going entirely in the wife's house, wife's name. And hubby gets an appointment scheduled for him by the lawyer that's closing the deal, which is the law firm that handles the real estate transactions or all the referrals from this real estate agent. So that firm sends hubby to another lawyer who's now partners with that first lawyer, became partners with that first lawyer 6 months later, where they had arranged the appointment and they even paid for the ILA. How independent is that ILA? They arranged the ILA and even paid for it. So ILA really needs to be, you need to get ILA, here's a phone book.
Yeah.
What?
Yeah. I agree with that comment 100%.
We won't even tell people where to go. Like if someone comes in and needs ILA, I won't even say call Scott. I just say you need to call someone, and it's not someone in my office, and I'm not referring you. Here's the Law Society directory. That's our go-to.
Why are we directing them?
Why are we directing them? The thing is, the ICCRC requires it in your retainer, and that was something that I thought was proactive in creating a claim. Law Society doesn't require it yet.
I find that people like it when you tell them you have a right to do this. You kind of like, haha, if there's ever an issue, they don't. I haven't had anyone complain. I haven't had any issues. We've terminated.
Talk to me in 30 years.
I know, and of course, I know, like knock on wood, I know it's coming. But to date, we haven't had any complaints, and clients like the transparency I found. So I'd rather just be honest.
Okay, Scott, do you want to answer this one? Back to the small claims matter. Why would you not take on both parties as plaintiffs? They both have an interest in the outcome, and leave it up to the court to delete one party.
And sorry?
Leave it up to the court to delete one party. What?
So in this particular situation that I'm referring to,
I don't know if it's that one though.
I think they're talking about the two houses side by side.
Yeah,
I
think they're talking about two houses side by side, individually owned by each brother.
No, that was the provincial regulator municipal.
Oh.
No, I think they're talking about Scott's question.
Oh,
I think
okay,
they're talking about
sorry.
Scott's scenario where he
The
had
subcontractor.
the contractor and the subcontractor.
Oh, okay, sorry.
so we're looking at the question there that's posed by Mike Ramsey.
Yeah.
So that is actually what ended up happening. We determined that we weren't deep enough into it. And to put a stop sign in the subcontractor and say, whoa, hold on here, you got to go get ILA, you decide what you're going to do, and whether you're going to sue our guy or whatever, but you got to go. And we were able to take the general contractor forward.
And the point of that answer, bottom line is he recognized the conflict, and then the answer to the question is to divest yourself of the conflict and move the one party as soon as you recognize it. If you can, after you recognize a conflict or a potential conflict, I think you're putting yourself at risk.
So have you, Val, ever seen the court call conflict in your years?
I've been trying to recall that, and in my experience, the courts shy away from it. The biggest conflict that I would deal with would be in careless driving fatalities. What happens is, defendant is charged with careless driving. The public interest is high because we're dealing with a fatality. It then swoops the insurance company to represent the defendant. Okay? And now, my concern has always been, the insurance company is pushing this on and on and on because their interest is to delay the civil process, and their interest is to minimize their particular liability in the circumstances. So they're in there getting all the information they need so they can do whatever spins they want. And I'm always wondering, you're advising this person whether or not they should take the plea, because we're now having judicial pretrials, we're now coming up with suitable alternatives, we're now coming up with pleas, and you have to provide, it's our obligation to provide them what the resolution is and then give them the legal advice. I often wonder, how is the insurance rep who has a self-interest impartial? Why is that not a conflict? But it happens all the time, and I've never seen the courts step in.
True. Very true.
I had it happen
Can you
once.
stand in though? Could you stand up and say, I believe that this is a conflict of interest, and have the courts address it?
I've had those conversations in judicial pretrials, but it's never gotten to the point where in trial. But I do know Crown counsels who have been in trial situations, and their witnesses on the stand, and then they begin to realize that their insurance witness is now in a conflict position, and that they can no longer proceed. So I don't particularly understand why, I never did until this session, why it wasn't why it wasn't brought to everyone's attention. That's a conflict, you can't do that. I now recognize that most people, and I mean this nicely when I say it, really don't give a damn until the Law Society gets involved.
Yeah.
So at the end of the day, what I'm getting out of this particular lesson is you need to CYA, and you need to know where the conflicts are to CYA to protect yourself, because this seems to be more like the rules require you not to act in a conflict of interest, and you're talking about your license.
Alexei?
I actually just want to give you an example because I came up with something recently. So, as you know, Valerie, usually the trucking company is charged and the driver. There is a conflict of interest right away. So what happened is basically two defendants, and the trucking company hires a representative, a paralegal, and says, okay, you deal with this. The paralegal representative, taking money from my company. Meanwhile, I just find out that the company says to the driver, oh, it's your fault, so we're going to take the money from you. So the driver pays the company pays the paralegal goes, makes a deal, and basically the deal, and the paralegal got the main instructions from the company, and it says, okay, get this withdrawn and plead this one that the driver got or something. So the driver is pleaded as is, the company's charges withdrawn. Then the driver is like, wait a second, so I got a ticket for $50. I paid $700 for representation, and I pleaded as is. And what did I do? And that's what the client actually came out to me and kind of what happened? And this is such a huge conflict of interest. How could you represent, and exactly like Scott said, the best interest is to throw someone else. I mean, just when you see something, we talk kind of theories, but when you see a real person who says, listen, $50 ticket, and I paid $700, and they did nothing for me, and I'm like, yeah, you can appeal it, it's kind of a clear way you can appeal it. How much would it cost? $1,500. What? Yeah. So, and it actually kind of, I like to bring it to personal level. When you see a real person who actually, truck drivers, they don't speak English, so they don't know what they sign with. The employer gives them something to sign, and they don't know what it all means. I felt so bad for the guy.
Yeah.
Our company deals with these all the time. We deal with those all the time.
Yeah. Oh,
and it turns into the guys when they come to the court. I tell them I'm here for the interest of the trucking company. Yep. I have no interest to you speaking to your matter. I said, and I feel really bad for the guy, and I even bring it to the Crown's attention as well, which helps force the adjournment. And that gets it, because there's companies out there, insurance companies, that trucking companies pay to have that legal representation. And when they come across my desk, I know immediately when it's a driver and it's a trucking company, it's the trucking company paying, and these guys show up, and I wait for them, and as soon as I see their name, I call their name out and I have a chat with them and say, you gotta walk away right now, get an adjournment, and the Crowns are open to do that.
But it's the same. Right? It's the very same thing as Val's talking about, except the civil side of insurance. The insurance company is the one paying, like Val said.
And I always ask myself this one particular question, and this goes back to your scenario, is that you're taking instructions from one party, but it's affecting another party. Mm-hmm. And if that party isn't having a say, then they're not being properly represented, which they need independent. If your actions are going to affect the other party, then that other party either needs to sign a waiver, or that other party needs to be told to go get independent legal advice. What you're doing when you recognize it. So, yeah, I totally agree with you. We actually run into conflicts of interest every day more often than we think. Mm-hmm. The bottom line is, if you think you're in a conflict of interest situation, act on it. Mm-hmm. Because, like you said, you're talking about abiding by the rules of the law society.
Cover your butt, right? Okay. I'm going to say thank you very much to those who attended via webcast and a couple of very interesting, humorous chat comments.
And there's one other comment before you close it down. Someone might be able to comment on this. Ever had a stunt driving matter, passenger in the trunk, and if so, how was it resolved?
Ever had a stunt driving what?
Matter, passenger in the trunk. Because if you have a passenger in the trunk of a truck, in the back of a pickup truck, that is under the definition stunt driving.
Going to the drive-in.
Yes, I've had that. Yes, I've had that as a prosecutor, and it was a catastrophic injury where the two people in the back of the pickup truck, one ended up with a double hip replacement, the other ended up in a wheelchair. They were the age 15 and 17. And the 5 in the seat-belted area, the cab of the truck, all had no injuries because the 2 in the back of the truck were thrown. So I can indicate to you in a situation like that, that stunt driving charge, they're looking at potential incarceration, giving the catastrophic injuries, and you would be trying, if you're advocating, you would be trying to get a careless.
Yeah, exactly. Okay, so thank you very much, everyone, for attending. If anyone knows, I'm going to be looking to, I have a few people that might be able to shed some light. I want to offer a CPD in the new year on construction lien, given the recent changes, condominium, correct, and careless. Might have you do it, Val. The new changes to careless and downloading. And Mark will be interested in that. And I'd just like to thank everybody and invite everyone in person, or if there are people in webcast close by, we're going to the general. The back room is reserved. Food is on Durham College, and I hope everyone will come. And thank you very much.
Scott will be doing karaoke.
Let me present it on camera.
Leanne, thank you so very much. Oh, this is it.
Yes, I'm not to do this.
Is that microphone off?
Start.
I don't like that.
No, I got it.
I won't be without you, but.
Are you coming? Oh, good. Val, talk to Alexi for a minute, and yes. Do you know Val?
Yes.
Oh, okay, forget it.
I've been in Europe a couple of times.
Please tell me you're coming.
No idea.
Okay.
Something back.
My client.
What are you talking about?
No.